Yes.
May I, Lords, one fresh matter, writ appeal I have filed arising out of Lords Karnataka Land Revenue Act, Lords. I was not a party before the writ court. However, Lords, my revenue entries were standing in my name. Lords, without notice to me, Lords, the revenue entries have been changed subsequent to the order. I have filed an appeal, Lords. May I request Lords to kindly
After 2 weeks.
any date.
26 subject to removal of office of this. Provided office of this.
I am moving the memo seeking for to hear IA number 1 and 2. In this matter, it is a PL. Straightly, this case is to shift the offices of Krishna Bhagya Jala Nigama and Karnataka Niravari Nigama to North Uttar Karnataka, please.
What you are saying? What is the request?
IA number 1 was filed to restore the PAL.
PIL will come. Whenever it comes, we will restore.
For non-compliance of the office objections.
So then file the application.
No, he has brought no objection to me and I am moving the application.
Get at least up 10 days. Application only.
Application. Same 26 application, list application for recall.
This honorable court directed the respondent to change the kata in my name basing on the sale deed. In spite of it, they have not made. I made a contempt petition.
Listed once you remove the office object.
Yes.
No need to.
I have already removed the office
And
objection.
don't worry, you will list within 1 week.
Will be listed.
Yes. First
My
and
lord.
second. Yes.
Writ appeal, my lord. Fresh matter, my lord. I have complied with the office objections, my
Then it
lord.
will be
The matter has
listed.
not
No,
been
ma'am.
listed, my lord.
If it is complied with, it will be listed.
My lord, it is 2023 matter, my lord. I have complied with the office objections long back. my lord.
No urgency. In
Please.
your normal, usual.
Please.
Writ petition, my lord. I'm sending a memo. Complied office objection for second time, my lord. It has been listed before this court. You have complied the office objection.
Mic is there.
Writ petition, my lord. It has been filed in 23, my lord, 2023.
23.
Yes, my lord. And even the office objection has been complied.
Filed in 23.
Hello?
Filed in 23.
Yes, my lord. 2023, my lord.
So what you are doing for 1 year?
No, we have complied, my lord. It has not been listed, my lord. For the reason I am moving a memo, my lord.
After 3 weeks.
My lord, CL number 14, 28-6. Paying for adjournment, my lord, CL number 14.
Bill number 40.
14, my lord.
40.
My lord.
40.
Yes, 14.
14.
Yes.
4. What is it? One writ appeal.
Yes, my lord.
One time.
Yes, praying for time.
Is connected with 13. So 13 or 14 both.
Yes, my lord. I am for 14, my lord. Maybe
For
adjourn.
Vijay Kumar.
Yes.
So 13 is also Vijay.
KV Narsimhan, my lord. KV Narsimhan, CL number 14. Serial list 1, CA 14, my lord. 14. KV Narsimhan.
14. After 2 weeks, 3 weeks.
Oh,
After 3.
Satya.
The request of learned advocate, Mr. So and so. For the appellate.
3, sir. Okay.
Listed after. To be listed on 19th of July.
My lords, praying for adjournment in item number 16, my lords, 16. Item number 16, my lords, adjournment.
16.
Yes, my lords.
Yes.
16 or
Time.
60?
My lords, 1 week, 16, 1 week.
Same order. 19 July. 19 July.
Much obliged, my lords.
The contempt matters, seal number 1, Mr. Chetan B.
Not in this case of record, not to be placed before the bench. Number 1. Where one of us, interpret Honorable Mr. Justice K.V. Arvind, Director, is a member. Not before this.
This seal number 2. Mr. Hussain,
Same.
the petitioner has filed this contempt petition against the willful and deliberate non-compliance of the order dated 1st August 2023 by this honorable court. That this honorable court had
Not before this bench.
before other bench.
You go to other bench.
Give a small date or tomorrow.
That we don't. Will be processed and placed before the appropriate bench. Yes. Next.
Seal number 3, Mr. Shant Kumar Kesi.
Paper, the complaint, my lord. Submission, my lord, the oversight, the direction issued, they respond to and
Notice returnable on
I'll make
13th
it.
of. arrest.
Deputy Commissioner are not a made a party, my lord. Deputy Commissioner, a direction to issue, Deputy Commissioner and the Tahsildar. I made a Tahsildar party, but Deputy Commissioner is not a party.
Returnable on 16th July.
I permitted to insert.
Seal number 4, Shrimati Vaishali Lekre.
Notice.
So State Election Commission which has filed, Election Commission has filed against the government.
This election,
State Election Commission is the complainant.
you are for election.
Yes. There is an undertaking, my lords, to the order your lordships which starts at page 19. None of the reservations are not given.
So undertaking was filed by whom?
My lords, by the first accused, the learned Advocate General gave the undertaking on behalf of the undertaking is at page 21.
By Secretary of the Parliamentary. Undertaking, where is the undertaking?
My lords, page 21, my lords, running page 21 in the contempt. It should have come by January itself. There is one delimitation for the, none of the panchayats are working today. There is no functioning of the Jilla and Taluk panchayats. Kodagu district, they were to give the delimitation and reservation, and for all the Jilla and Taluk panchayats, reservations had to be issued.
Here the practice is to file memo of compliance.
Well, that's actually undertaking.
Here it is an undertaking.
Undertaking given, my lord. Because the
Delimitation
court had
completed.
recorded that they'll file it by 4:30, the undertaking. They have filed it as a,
They should file on oath, on affidavit.
actually an affidavit, my lords, but it is signed by the,
So this
because they filed it subsequent to the order.
comes to the question of enforcing the, in a given case, memo manner.
No, but it is signed by the first respondent, the accused and the learned.
Hard learned senior Commissioner Phanindra for the applicant the state election commission. State election. Notice returnable on
Could I request for an-
26th of June.
please.
That's, my lords, another week could be extended, my lords. It's Code of
Why
Code
you are
of
not undertaking delimitation?
Conduct is continuing up to 16th, my lords. Because of the MLC elections.
So you want
That's the
notice
code of-
returnable on 13th June.
My lords. Your Lordship may.
No, that you can't delay such processes. They are essentially democratic processes. And that
4
too
weeks.
pursuant to the order,
4 weeks, my lords. Your Lordship had granted 4 weeks that I,
24th,
26th, my lords.
24th is neither 13 nor 26.
26th, my lords. I would,
You take instructions, we'll give time if needed, but you just activate yourself in taking instructions at least. When you are going to undertake the process. Yes, for 24th.
Seal number 5, Mr. Shekhar L.
What is it?
Lord, there is a direction by the honorable learned single judge Mela to comply after submission of medical board report Mela. Accordingly, Mela, he submitted medical board report in the month of December 2023 itself. Till the time, Mela, there is a direction not to relieve from service.
So decision is to be taken about what?
Mela?
Decision is to be taken about what?
Not taken any decision for
What
allotment.
decision is required to be taken?
Allotment of permanent work, Mela.
Allotment of permanent work.
Permanent work. On the
Work
basis of the medical certificate produced by the workman. As per the direction of the
Notice returnable on 27th of June.
SPL matter, SC number 6.
In this case,
Case.
I represent the petitioners, my lord. In this writ petition, my lord, the prayer is at page 26, my lord. The petitioners have sought to consider their representations, my lord. The representations are in the nature of a direction to the state government, requesting them to grant the land, which has, wherein, my lord, the iconic film star Dr. Vishnuvardhan has been cremated. My lord, on 30/12/2009, the iconic film star has demised, and subsequently on 26/4/2010, Dr. Vishnuvardhan Smaraka Pratisthana has been established by created by the state government. And subsequently, my lord, the land in which he has been cremated, that 10 guntas of land has remained, and now my lord, the petitioners and all other fans have been allowed to perform puja twice in a year. One is on his birth anniversary, as well as another one is on his death anniversary, my lord. Annexure H is the letter written by the Abhiman Studio consenting to the state government. The letter has been addressed to the Deputy Commissioner, my lord, thereby consenting to give away that 10 guntas of land where the cremation has took place.
What is this petition? 45042.
That, my lord, earlier, my lord, there was a challenge to the cancellation of grant by the Abhiman Studio. In that writ petition, my lord, we were impleaded. Subsequently, my lord, a direction has been issued to us, directing us to give representations. And subsequently, based on that direction, my lord, annexure AA 10 to AA 19 representations have been given to the state government, which has which is to be considered, my lord.
So do you want to construct a memorial of a film star?
Please.
That cannot be subject matter of court matter, and that to public interest. What is public interest?
My lord,
what is public interest in creating a memorial of a film star? Howsoever he may be renowned. That too before court of law. That too before the High Court in PIL. Sorry, Lord Learned Advocate, Mr.
Notice may be ordered, my lord, so that the state government is under consideration. It has already annexure G, my lord, kindly appreciate page 56. Annexure G, the survey sketch has been marked and the land has been marked for that purpose.
Very subject matter doesn't fall within the parameters of PIL.
Already state government has demarked the land also, my lord, way back in the year 2017. And subsequently, due to the pendency of the earlier petition, my lord,
what is the element of public interest in this?
My lord, the fans are
to construct a memorial. It may construct, but court is not coming in.
But the land in which, my lord, he has been cremated is the government land, and hence, my lord, the interference of the government is required. Hence, I have sought for a writ of mandamus to direct the state government, my lord. Kindly appreciate the prayer, my lord, page 26. May I read the prayer column, my lord.
The petitioners heard learned advocate Mr. Arun KS for the petitioners. Petitioners, 7 in numbers, claim that they are the vigilant citizens of the Bengal. They have brought this petition in the nature of styling as public interest petition. Paragraph. The prayers made are inter alia to direct the respondent state and its authorities to consider the various representations annexed along with the petition. It is next prayed to direct the state authorities to pass necessary orders for grant of 10 gunthas of land in survey number 26, new survey number 68 of Maila Sandra village, Ken Jerry Obli, Bengaluru South Taluka for construction of Dr. Vishnu Vardhana Smarak Bhavan. The representations stated to have been made by the petitioners is in respect of the same request for granting land for the above said purpose. Full stop. The case of the petitioners in nutshell, stated in nutshell. Is that Said Dr. Vishnu Vardhana was an iconic film star of Kannada film industry, and he has left behind crores of fans who stood praising his capacity, praising his acting and various praising his acting skills. The petitioners state that land is required to be granted for construction of a memorial in the name of the said film star. It is in this regard that directions are prayed for setting out the various facts about making of representation to the state authorities for the for seeking the grant of land. Certain internal correspondences are also mentioned in the petition. Paragraph. Construction of a memorial of a film star cannot become a subject matter of public interest litigation. It is difficult to visualize as to what public interest could be achieved by the petitioner insisting for grant of land for the purpose. Full stop. The subject matter brought before the court could be said to be hardly fit to be considered in the public interest jurisdiction. Full stop. It is paragraph. It is entirely the domain of the authorities to consider such measures and requests. Full stop. The court, especially the High Court, exercising the public law jurisdiction, cannot have any say in the matter. Full stop. The petition, the present petition, projected as public interest petition, is entirely misconceived, containing no element of public interest. Full stop. It could have been dismissed with heavy cost. However, taking a lenient view, without cost, without imposing any cost, the petition is dismissed, summarily dismissed. So it is already constructed,
My lord, I have stated so.
not stating that.
I have stated, my lord, in the writ petition order only it has been mentioned. Now, my lord, the Smaraka has been constructed. Now the question is, my lord, the place where he has been cremated, that 10 guntas of land, which has been emotionally connected to the fans, my lord, it has been considered as the Punya Bhumi. To that extent, my lord, I am seeking the relief. Not to the extent of entire Smaraka, my lord.
This was earlier was a public interest petition.
No, my lord, it was a writ petition.
Full stop. It is to be noted. It will come in between. I'll just arrange it subsequently. It is to be noted. It could be further seen from the record of the present petition that the earlier writ petition being writ petition number 45042 of 15 was filed by same person.
No, my lord, it has been filed by the.
By other petitioners in relation to the erection of monument of the very film star, full stop. In that proceedings, comma, the stand of the authorities was that stand of the authorities was evinced, EVA and CD, by filing a memo stating that the state government had passed a government order dated 10/1/2020 to shift the site of the monument from Bengaluru to Mysore. It was stated that the construction of monument was complete and that in pursuance of the policy decision to shift the monument from Bengaluru to Mysore, a sum of rupees 8 crores was already expended. Given this background of facts, it is incomprehensible as to how the present petition could have been filed, seeking the directions. So now this is really case for a cost.
No, my lord, I have stated it. I have not suppressed that
is
fact.
good. So if stated then less cost, not stated then more cost.
No, I have filed that entire order sheet, order copy.
What cost you will fill up?
No, my lord, I am
This
sorry.
can't go without cost.
I am sorry, my lord. I am sorry.
Cost of rupees
I am sorry, my lord.
25,000,
I am sorry.
only 25,000
I am sorry, my lord.
against 8 crores spent. by
No,
the state
8
government.
crores was state's fund, my lord, not the individual fund.
There will be a day when we have to start imposing cost on such PILs. Yes, next. So next is same.
No, my lord, this is
Another film star, another monument.
No, my lord. This is with respect to formation of the solid waste management unit within the village limits, my lord. Survey number 77 of a village, wherein, my lord, the applications for grant of land is also pending. Suppress.
Don't type. Yes,
The applications, my lord, for grant of land in that particular survey number.
just type out. Yes, what is it?
My lord, this is with respect to the formation of the solid waste management unit within the village limits. Now, my lord, in that survey number, already there are several requests or representations made or applications have been made to grant of that survey numbers, my lord. And suppressing all those grant orders or the applications pending, the state is intending to form the solid waste management, that too within the village limits. Now, my lord, I have given, the petitioners have given 4 representations, my lord, annexure M, N, P and S. Seeking to consider those applications, my lord, the present petition has been filed. In the same village, my lord, there are other places wherein outside the village, wherein the proposed solid waste management unit can be shifted.
So again, same thing, you want to shift the, you want to cancel the solid waste management system.
Pardon, my lord?
You want to cancel the decision of installing the solid waste management system.
No, my lord, I am only seeking the transfer of shifting of that which is which is intending to farm within the village limits.
The court is not running such things, Mr. Counsel. Solid waste management and erection of monument and laying of road. This is not the function of the court. Are we here to are we expert in dealing with the subject? Whether this is to be shifted or installed or not shifted, this capacity,
My lord,
that capacity.
our only apprehension is that, my lord, the solid waste management which is intending to be formed is within the village limit, and there are other survey numbers in the village where it can be shifted. That is one point. The second point is that, my lord,
My lord, the order of the deputy commissioner has been passed on 31st May 2023, reserving this 2 acres of land, my lord, for formation of the solid waste management unit. My lord, and the possession has already been handed over to the, my lord, the executive officer on 17/1/2024.
Where from you?
My lord,
in between, my lord, we have given representation. That has not been considered. Annexure M, N and P and S, my lord. And the admittedly, my lord, the admission applications for grant of those lands is pending for consideration before the authorities. That has not been considered.
my lord, page 26, writ petition. My lord, paragraph I, the handing over of possession is mentioned. And my lord, in page 24, paragraph E. Page 24, paragraph E, my lord gets it. And page 26. Order of the DC is not challenged. And the petitioners are seeking for a positive direction, my lord.
Correct, to cancel.
Yes.
How can it? So possession is also taken.
Yes, yes. My lord gets it at page 26, paragraph I. My lord, annexure T.
Page?
My lord, page 6, annexure, my lord, it's not
Anyway,
numbered.
but
my
possession,
lord.
we record your statement. Possession is taken. Everything is
No,
taken.
in between, my lord, the representations have been submitted by the villagers. That has not been considered, hence, my lord, the
My
petitioners are
lord,
before
page
this.
99, I think the English translation is at page 100. I don't have the English translation. Annexure T.
Hmm. All learned advocate, Mr. So and so were petitioners. Full stop. The petitioners were 40 in numbers. Projecting themselves as public spirited persons. I have filed this writ petition in the nature of public interest litigation. What is prayed by the petitioners is to direct the respondent authorities to pass orders to cancel the proposed installation of the solid waste management unit at survey number 77 of Doderi, DODDERA village, Avrekere, Hobli, Bengaluru South Taluka. It appears that the petitioner have proceeded to make representations in the subject which they want to decide. The record paragraph of the petition itself reveals that the elements in the petition themselves reveal that not record. Deputy Commissioner Bengaluru, by order dated 31/5/23, reserved the said land, survey number 77, at measuring 2 acres at Doderi village for the purpose of formation of the solid waste management unit. Full stop. The petitioner has stated that the said order was passed by the Deputy Commissioner it further transpires that the 2 acres of land, the possession of the said 2 acres of land was handed over to the Chief Executive Officer, Bangalore South Taluka Panchayat on 31/10/23. Full stop. The handing over letter, from a copy of which figures on record of the petition.
Manad, handing is 17/1/24.
17/1/24, not 31/10/23. The handing over letter, copy of the handing over letter figures on record. Integrated page 2162 TO2, 220. The possession of the land has also therefore been handed over to the competent authority for the purpose of installing the solid waste management system. Also, this is further fortified by communication. Dated 6/9/11. This is, no. It appears that no, don't write that. Full stop. In addition to the above admitted facts, comma, the installation of, it has to be observed that the installation of the solid waste management unit would going to subserve the public good only. Full stop. It is in public interest that the such project is developed and installed at the place to treat the solid waste. Full stop. The petitioner has proceeded to seek the positive direction, seeking the authority, requiring the authorities to cancel the project and cancel the decision, full stop. The present petition could be said to be could hardly be said to be a public interest petition. The prayers rather run contrary to public interest, and the petitioners want cancellation of the proposed project. Full stop. The petition is a publicity-oriented petition. Petition appears to be a publicity-oriented petition, deserves to be dismissed with cost of rupees 15,000. It is accordingly dismissed. The cost shall be paid to the
My lord,
High Court Legal Aid
the
Committee.
petitioners are the
within 15 minutes.
villagers, my lord, and they are only concerned about their village. There is no publicity involved, my lord.
What
My-
else it is? Everything is over and now you want to cancel for what?
No, my
purpose?
lord, kindly appreciate the representations be given in between, my lord. That has not been considered. 31/5/23 is the order of the deputy commissioner. 17/1/24 is the taking over of the possession. In between, my lord, 4 representations have been given by the petitioners.
So we
That
can-
has not been considered, my lord.
We can take out the cost and shift to the earlier petition. Either of, just choose the cost. In which petition you want to pay the cost.
My lord, I'm only urging before this honorable court, my lord.
Take out the cost part, all right. But as we are saying, someday the cost will start. So without cost dismissed, yes.
December 8, Mr. Badri Vishal.
The petitioner, my lords, is running a medical research institute and, my lords, a hospital cum medical college. Adjacent to the college and the institution, my lords, is a poultry farm. In the year 2016, your lordships will see at page 43,
You are appearing,
For the board, your lordship.
board.
Respondent number 2.
pollution board.
Yes, your lordship.
please.
Yes.
At page 43, my lords, in the year 2016, the pollution board, my lords, conducted an inquiry and submitted an inspection report. The relevant page, my lords, is at page 44, where observations were made during the inspection. At page 44, last paragraph. my lords. The inspection had taken place on 12/4/2016. The observations made, my lords, the third one, sheds are constructed above.
They are putting up hospital.
We have already established, the petitioner has already established a hospital and a
They
research
already
institute.
established hospital.
Please,
Then, yes. Now, yes, proceed.
please. Now, the inspection report, my lords, clearly mentions in the observations made that the poultry waste is collected at the,
This inspection report is dated
this is, my lords, 2016,
16.
please.
Yes.
And, my lords, at the next page, at page 45, there was also an observation which was made at the first line at page 45. Poultry feed plant of capacity is in existence in the premises without prior permission from the board and supplied to the feed to the poultry through mechanized feeders. There was overflow of sewage from the septic tank in the land which belongs to the proposed Dayanand Sagar University. These were the observations made. Please see, my lords, at page 46, the recommendations made.
So poultry feed plant of capacity is exist in the premises without permission of the board.
Please. These were the observations made. On the right-hand side, my lords, at page 46, there were certain recommendations made in the year 2016. This is how the report concluded.
Yes, then,
Please, the poultry authorities shall clear the poultry waste regularly to overcome the smell nuisance. Overflow of sewage from the septic tank shall be stopped within a week, and there shall not be any further overflow from the septic tank.
where you are reading?
Please, at page 46, my lords, there is recommendations which have been made by the pollution board.
Yes.
Please. The fly and smell nuisance shall be stopped within 15 June 2016. The applicant shall apply and obtain consent for operation for operating the plant. If the authorities fail to comply the above, poultry farm shall be shifted, closed in a phased manner. Now, this happened, my lords, in 2016. Thereafter, my lords, there have been various complaints which have been made by the villagers and the petitioner at page, my lords, 47 onwards. In 2018 itself, saying that nothing of this had been complied with. Then, my lords, in 2022, at page 50, the respondent number 5, that is the poultry farm, my lords, obtains, after a lapse of 6 years almost, he obtains a consent for operation.
Poultry farm.
The poultry farm obtains a consent for operation on 7/5/2022, which is valid till 31/12/2035. That your lordships will find in the last line of page 50.
Yes.
At page 56, my lords, an annexure to this consent for operation is annexed, which is subject to, my lords, at condition 8. There shall not be any complaints by the surrounding residents on water and air pollution and smell nuisance against the operation of your poultry farm. There were other guidelines also issued. The first guideline itself, my lords, is on the basis of an applicant shall follow the environmental guideline for poultry farm laid down by the Central Pollution Control Board dated 17/8/2021. Now, this guideline, my lords, I have attached at page 57. I'm running a, my lords, hospital.
Some special hospital or general hospital?
It is a general hospital, my lords, and a research institute. It is a medical research institute coupled with a hospital and a medical college.
So any norms are there for permitting poultry farms in the hospital area or locality, residency?
At page 68, my lords, this is the Central Pollution Guidelines, Pollution Board Guidelines. It starts at page 57. At page 57 is the guidelines. Relevant page at page 68. It gives us citing criteria. These guidelines, my lords, was published in August 2021.
Which is relevant?
Relevant at page 68.
Yes.
Clause 7, citing criteria. New poultry farms set up after issuance of guidelines should preferably be established 500 meters from residential zone in order to avoid nuisance caused due to odor and flies, 100 meters from major water course like river, lakes, canals, etc., etc., 100 meters from the national highway and 50 meters from the state highway, 10 to 15 meters from rural roads, internal roads, village roads. The poultry shed should not be located within 10 meters.
Any provision to review the consent?
Please, there is, my lords. In fact, the at page 40, the consent for establishment itself, operation itself, at page 56,
Yes.
mandates at 8, my lords. It mandates that there shall not be any complaints by the surrounding residents on water and air pollution. And at page 46, my lords, they categorically say that if the authorities fail to comply with the above, poultry farm shall be shifted, closed in a phased manner. This is what the pollution board also says in the year 2016.
Your Lordship, if I may be permitted to submit, the consent for operation was granted in 2022. It has been 2 years which has lapsed and there is no representation from the petitioner to the board to look into this matter, Your Lordship. The board was not aware that it has not been complied with. No, without giving a representation to the board, the writ petition has come to be filed after a lapse of 2 years before this Honorable High Court, Your Lordship. All these grievances, if made out in a representation, we will consider the representation in a time-bound manner and take appropriate measures, Your Lordship.
The petitioner is a trust which has filed this public interest petition, stating inter alia that it is running a hospital, that a poultry farm is located in the vicinity. It is the case that the said poultry farm was initially established without the permission of the Pollution Control Board. Subsequently, in the year, full stop, subsequently, it was stated on 13/5/2012,
22 minutes.
22.
7/5/2022.
Consent was obtained for operating the poultry farm. Full stop. One of the condition in the consent is that there shall not be any complaint by the surrounding residents on water and air pollution and smell nuisance against the operation of the poultry farm. Full stop. The precise case of the petitioner is that the poultry farm is not only creating a nuisance because of the smell it emits, and that endangers the well-being of the patients treated in the hospital, it is generally to be considered as against public interest when the same is located near the, permitted to be located near the hospital and causing the smell nuisance as above, which is in turn threat to hygiene in general also. Full stop. Notice you are appearing?
Yes, Your Lordship. Respondent number 2, Your Lordship.
How do you appear?
Through A. Mahesh Chaudhary, Your Lordship.
On behalf of poultry farm or
Behalf of the
pollution?
pollution board, Your Lordship.
I appear for 1 and 4, my lord.
We thought you were appearing for poultry.
Your Lordship, for the board.
Learned Advocate Miss.
Krishika Vaishnav for A. Mahesh Chaudhary, Your Lordship.
What is your good name?
Krishika Vaishnav, Your Lordship.
Vaishnav.
Krishika Vaishnav.
Vaishnav for money for
A. Mahesh Chaudhary for R2, Your
Ms.
Lordship.
Chaudhary for the respondent pollution board appears. Next is notice.
Yes, sir.
1 and 4, my lord, state.
On behalf of you. are
State
for-
1 and 4.
For 1 and 4.
Please,
Whereas
ma'am.
learned additional advocate
Sarita Kulkarni.
Sarita Kulkarni appears for 1 and 4.
For R3, notice has to go, my lord.
Respective respondents, especially the respondent pollution control board, shall file reply before the returnable date. Notice returnable on. When you will file? Within 3 weeks?
Yes, Your Lordship.
3rd of July.
Grateful.
You are Badri Vishal.
Please.
Yes.
This is number 9.
I'm
Diksha
appearing for
Yanam.
petitioner.
Yes.
This is pure, my lord, not publicity oriented PIL. This is, my lord, genuine petition, my lord. The 238 acres.
Serial number 9.
Yes,
Yes. What is it about?
this is, my lord, the for utilizing without denotification from forest land. The government has started, the authority, Tahsildar started to formation of a layout for granting the sites for refugees. Kindly see in page, sorry, my lord, survey number 76 and 31 of Bailkuppe village. My lord, total extent of land is 238 acres. Initially, this land was granted, my lord, to Mysore Tobacco Company. Thereafterwards, that it is returned to the Agriculture Department, and Agriculture Department, my lord, has returned
to the government. Government proceedings has been initiated, Annexure C, in page number 42. And my lord, translated copy, my lord, at the time of filing not produced. Translated copy produced at, as per memo dated 27/5/2024. Court of Sir, 27/5 memo of translation. That translation may kindly be seen for Annexure C, my lord.
So please give me a copy, sir.
Copy already served. Last time notice issued, copy served, and without serving copy to the government, it will not come at all.
Take
I'll
it.
serve. That is not an issue. I'll serve once again.
Okay.
But my respectful submission is, now, my lord, government has issued notification by virtue of, my lord, Supreme Court direction. I am producing that also. They should not, my lord, during the pendency, standing tree cannot be, that is, my lord, my prayer. And producing that notification. Notification has been issued by the, my lord, by referring by direction issued by the Supreme Court in Godavaram case. Notification, my lord, has been issued, entire, my lord, extent of land, my lord, has been notified as deemed forest. Kindly see, this is the notification issued, my lord, on 21st May 2022. Your lordship can turn, my lord, in page number 11. In page number 11, second column, my lord.
So what kind of construction is made?
My lord, that they are making layout by removing the standing tree. The Tahsildar is, my lord, forming a site for, since, my lord, in Bailkuppe, already there are a huge number of Tibetans, my lord, has already colony has been granted. Now, apart from that, my lord, that this is for, my lord, the Rohingya refugees. That is
Refugees.
Yes. Tahsildar is doing that, and representation has been given. Therefore, my lord, my respectful submission is, kindly see in page number 19, translated copy, my lord, your lordship directly will get the notification in page number 19. In the translation, the notification relevant para that I'll draw your lordship's attention. Thus, the district level committee, after reviving so and so hectare identified by the reconstituted expert committee, identified 221,554.20 hectares of deemed forest area, and 1,80,632.7 hectares of area conforming to the field of criteria but not included in the reconstituted expert committee number 1 report, totaling 3,30,186.93 hectares as deemed forest area. This list, my lord, your lordship would get at page number, my lord, that along with notification that we have produced, your lordship will get in page number 11, my lord. Third column, 8771 Mysore, in page number 11 in that.
But they are putting up some housing project.
It is not, my lord, denotified. And, my lord, it is a forest land, declared forest land, my lord. There is photograph that, no, my lord, housing, not housing project also. They are, my lord, the forming a sites and, my lord, distributing. By removing standing tree, photographs may kindly be seen for a moment. We have given representation. Representation has not been considered. In page number 50 may kindly be seen.
What is this additional document?
Additional documents that we have produced is, my lord, that notification issued by the, my lord, state government for declaring as these land are forest land.
Declaring as?
Yes.
So that is of which year?
2022, my lord. Gazetted, this is on, my lord, 21st May 2022.
So where is the photographs? So it is not denotified.
Not denotified. And my lord, this is as per Annexure C, it is handed over to the government. And by virtue of my lord, Supreme Court direction, Godavaram case, my lord, state government notified, entire extent has been notified. Therefore, my lord, I would,
Where it is located, situated?
this is Mysore, my lord, district,
Mysore.
Bailkuppe village. Survey number 76 and 31. That is border to Kodagu district. Photograph sketch.
40 of right?
Please, my lord. Prayer, my lord, kindly see. Prayer annexure H, we have sought, my lord, to consider issue writ of mandamus appropriated order direct respondent number 1 to 7 to consider representation complaint dated 17/11/2023 annexure H. That we have already given. Issue writ of mandamus appropriate order directing respondent so and so, so and so, so and so desist from the further encroachment of construction or alternative forest land situated in survey number 76 and 31. And my lord, sorry.
My lord, may I make one submission with my lord's leave? My lord, paragraph 14 of the writ petition may be seen. No particulars are given as to who, with regard to the alleged incident that is supposed to have taken place. Then my lord may take paragraph 17, first sentence. My lord, may I read the first sentence?
Native of adjacent district.
Pardon me, my lord?
He is a native of adjacent district. Eh?
No, my lord, 14 is there, particulars are not given. Then paragraph 17 may be seen.
In turn, we
It's a
are supporting
premature
madam because
may
my
I
lord,
make my submission, my lord. It's a premature writ petition. My lord may take paragraph 17, first sentence. It is relevant to state that upon reviewing annexure G, the entire villagers and the petitioner were shocked and surprised to discover that the revenue department is going to form an illegal layout within the government forest area. Going to form.
let them file affidavit before this honorable court.
Why premature? On the contrary, your laying down is premature without denotifying the land.
No, my lord, that is what they contend.
Let them file before this honorable
there,
court some
my lord,
affidavit saying
my
that
lord,
they are
where
not.
is to consider the
We have no issue.
representation.
We have no
My
any
lord
grievance.
my lord may fix some time. My lord, the representations will be considered in accordance with law.
Till then, my lord, that they should not remove
No,
standing tree.
that is what they contend, my lord. And I'm not given the complete papers also. I'm taken by surprise with all these submissions.
With great respect, I can produce, my lord, without filing entire petitions to the government, matter will not come before this court.
My
If
lord,
they are asking, I'll give, I have no objection.
With great
But
respect,
till then, my
even
lord,
I'm
standing
returning
tree, that is to be, my lord,
My lord, with
my
great
respectful
respect, I'm
submission.
returning
And
back
this
the
honorable court, vacation we have moved and
served on me, my lord.
notice has been issued.
Notice was
Issued.
was
Yes.
during vacation, yes.
Yes.
Yes. That was during
In this
vacation.
matter.
Yes, my lord. Notice was issued, directed them to, my lord, verify
My lord,
by the vacation court.
21st of May. My lord, with great respect, I'm returning back the copies that they have served on me. They are all incomplete.
I can't understand why madam is angry because, my lord, we are protecting
I'm not angry, sir. Be
interest
fair.
of the
Be
government
fair.
land, forest land.
Be fair, sir. I'm with you. Be fair.
No notices. We don't find any notice.
Please, notice was issued in the vacation court, my
My
lord.
lord, 21st May 2024.
21st, my lord. 24.
Accepting the reasons stated in affidavit application, I is allowed production of so and so and so and so, except notice.
Yes.
My lord, we will consider the representations. My lord may fix some time for that.
You file a reply.
Yes,
Very well.
please.
My lord, let
Till
a
then,
complete set be
standing tree
given, my
can't-
lord.
That standing tree, my respectful prayer.
Pending,
Tree cannot be removed by them.
then you are not able to get that order at the initial stage. Then now at this stage, when you are directing them to file, you will not grant it. Had this been a first occasion when we are considering the matter, we could have considered.
At that point in time,
So having not secured that order, interim order at the first hearing, now at
no,
this
we have, since my lord, the
juncture
same
will
kind,
not- Until they file, will not.
my respectful submission is this, my lord. First time when matter came up before the court, they have said, my lord, we will verify, and my lord, till then, my lord, since vacation court, my lord, that they have said. Under those circumstances, my lord, interim order was not.
My lord, I
I
don't
have
know what
appeared and I
transpired,
have
my lord, but I
requested.
object.
I leave it to this honorable court. If my humble request is not to remove the standing tree, that's all my,
My lord,
my lord, request. Standing tree photographs that we have produced, and annexure F is the photographs.
Yeah. I can't see, this thing is incomplete. That. My lord, there's no prima facie case made out, my lord. It cannot be on the basis of photographs and the particulars, my lord, that they have averred in paragraph 14 of the writ petition, which is bereft.
Or learned advocate Mr. So and so for the petitioner in this public interest petition. What is prayed is to require the respondent authorities to desist from PSIST encroaching from a constructing over or altering the status as forest of the land bearing survey number 76 and 31 in Bailakupe Gram Panchayat area, Bailakupe village, Rannahalli Hobli, Piriyapattan Taluka, Mysore district. The petitioner wants to protect and safeguard the site forest land. The case paragraph, the case of the petitioner inter alia is that the site survey numbers at measuring 238 acres and more are forest land, so declared, and the land is located adjacent to the river Kaveri, Kodu, Kodagu. It is stated that earlier in 1980s, the land was transferred to the Seeds Development Center, Agriculture Department, for research and development to grow different species of flora, seeds, and culture variants of plants. However, the same was transferred back to the Agriculture Department in the year 2002.
And then forest on 25/10/2003. Annexure C, Forest Department.
Forest Department resumed the land and it has been forest land. It is the specific case that the land is not notified, denotified as forest land. Full stop. The petitioner, who is an advocate by profession, has stated in the petition that he witnessed the activities on the said land whereby the JCBs, cranes and tractors were brought and large number of trees were cut and demolished. Full stop. The government's paragraph in this regard are found in paragraph 14 of the petition. So this yellow. Paragraph 14. The petitioner is a native of so and so so and so. On entire. Is the case of the petitioner that the said when he inquired about the activities, it was given out to him that some residential layout is to be executed over the land.
My lord, it's for Ashraya scheme, my lord. Ashraya scheme.
Under the
Annexure G, my lord, that Tahsildar order is also, Tahsildar, my lord, as Annexure G sketch has been produced.
However,
Translated copy.
it is submitted that without denotifying the land, in any case, no such activity which is other than forest related could be undertaken in respect of the land, over the land. Full stop. The petitioner submits that the state is already experiencing, has already been experiencing deficit in the forest land to the extent of 13%, and illegal encroachment and non-forest utilization of the forest land has to be eschewed, ESCHWD, in all circumstances. Notice was issued by the court on 21/5/24. On that day, it was submitted by learned advocate to the petitioner that there was an urgency in the matter. Full stop. Learned additional government advocate had accepted the notice and sought time to secure necessary instructions. Full stop. Today, the filing of paragraph. Today, when the petition comes up, the filing of reply from statement of objections is awaited. Full stop. Learned advocate for the petitioner presses for interim relief to submit that the activity of cutting and felling down of large trees in large numbers on the land is still continued. Yes. Which will seriously damage the character of the land, which is a forest land. Full stop. Learned additional government advocate press for time to file the statement of the objections. Time is granted till 3rd of July, before which date the statement of objections will be filed. Full stop. In the facts and circumstances case, when it is asserted that the land is forest land and not so far not denotified, yet the encroachment is being done and the trees are being cut, which are on the and trees on the land are being cut, it is directed by interim relief that the status quo shall be maintained with regard to the land by all the parties concerned.
My lord, may I make a request to see that complete set is given to me, my
Yes,
lord?
you did not request, we will give, entire set we will
I
give.
know you will give.
Sentence by
Much.
has produced notification dated 5/5/22 which shows that the land in question is a forest land. Sued by notification published in the Gazette, Karnataka Gazette.
21st March 2022.
21/5/22. Showing that the land in question is a forest.
My lord, may I make one submission? My lord, it was being submitted that even today the trees are being cut. Submission that was.
They're
made.
only saying status quo.
No, my lord has passed that order, but a submission was made saying that trees are cut even as on date 4th June 2024. My lord, in case the submission is not
They're
correct, then,
persuaded by the fact that land is still a forest land.
my lord, I will, no, my lord.
Nothing, you show something concrete about the layout plan.
No, my lord, I'll do that. But this submission, my lord, I'd like to have a.
Refute
this
it.
thing.
You are
Very
within the right to refute it, but
Very
today we are inclined to consider.
Very
Yes.
But
obliged.
The green bench matter, seal number 10, Ravindra Gajanan Pulle.
It's a rule 8B. sir?
No, my lord. It is Rule 6,
Rule
4, and Rule 31R6, as well as Rule 47, my lords.
What is the case? Let us-
So herein, petitioner was declared as a successful bidder in tender cum auction sale of a sand area in stream 4 to 6. And he executed a quarry lease deed valid for a period of 5 years. And a condition was stipulated that I should complete or carry out the quarrying minimum 50% target that has been notified in the environment clearance certificate. So in 1 year during COVID period, myself I could not achieve 50%. Rest of the period I have completed. That's why penalty of 1.5 crores or 1.553 or 5 crores was imposed. That has been reduced to 1 lakh rupees at par with other similarly placed tenderers.
So you are challenging page 24.
Yes, my lords. 24 and 24 is an endorsement issued under Rule 6(4), my lords. I may kindly be permitted to read.
Where is that endorsement?
Annexure A, page number 24, my
So that is the only challenge. no?
That is, and the Annexure B also at page number 26 in Canaries, and in English, it is at page number 32, my lords. That order has been passed. That order has been passed in terms of Rule 31R, which is not applicable to legally quarried sand and legally stored, my lords. The opening sentence in Rule 31R6 says, my lords.
So what is this Annexure B?
And Annexure B is an order handing over the stock, remaining stock of 30,000 metric tons to project director, contrary to law.
This case.
Yes, my lords. Because respondent number 6 is the project director.
So your lease expired when?
Yes, my lord. But
When?
but the issue is in 2022 itself,
Date.
6/5/2023 is the date of expiry of the quarry lease, my lords.
So 6 months would expire on
Yes, 6 months expires on October 2023.
5/1/24.
Yes, my lord.
But the issue is, what can be declared as a government property, that I may kindly be permitted to read Rule 6(4), my lords. At page number 29 of the book.
The Karnataka minor mineral concern.
Yes, my lords. May I read, my lords? The lessee or licensee shall remove or transport the minor mineral extracted from a quarry during the currency of the lease or license within 6 months from the date of expiry of the lease or license. If the lessee or licensee fails to remove or transport the minor minerals extracted within a period of 6 months from the date of expiry of the lease or license, the minor mineral so extracted shall be the property of the state government. And it shall be disposed as per chapter 8 of these rules. This is most important for our purposes, my lords. Herein, I have removed and extracted and stored in a designated stockyard outside the quarry lease area.
But it is extracted.
Beg your pardon?
It says that minor mineral so extracted.
Extracted. I have extracted from Mother Earth.
So it becomes property of state government.
No, after extract.
After 6 months, it becomes property of.
After extraction, I am permitted to store in a designated stockyard and thereafter it's transport on making payment of royalty.
You have stored at the stockyard.
Yes, my lords. It is not within the quarry lease area. If the area, the quarried mineral is stored in the quarry lease area itself, then the question of declaring that as.
I'll reply. I'll reply.
I'll reply, my lord, but.
No, let me complete.
No, I am answering the court question.
All right.
So upset. Lord, the order under challenge is passed by the deputy senior geologist.
Appealable?
Revision is.
Then you go.
Yes.
My submission, my lords.
Then it is a disputed question of fact. We don't know whether you have stored and extracted.
My lords, herein, the project director and the deputy commissioner are not the subordinate officers covered under Rule 53, my lords.
Why?
Because they are outside this. It's only departmental officers. Revision is applicable to them.
Let us say revision is under which provision?
Lord, there are two things, Lord. This is extraction in stream 4 area. Therefore, Lord, so far as any dispute arising, Lord, out of the grant of sand quarry under 31R sub-rule 20, Lord, they have to file a revision before the director of Mines and Geology. And in this petition, challenge is to the deputy, the order passed by the senior geologist. Therefore, 53 lies. Revision under 53, Rule 53. So far as, Lord, the sand quarry granted under 31R is concerned,
above the rank of additional director. The deputy director, yes, a revision would lie.
Yes.
Why should it not lie?
But my submission is, I have invoked the violation of Article 14. That is totally going to take away the provision of revision. It is passed without the authority of law, and constitutional validity is, though not I am going to challenge, but all other 3 quarry leaseholders are given extension. I am only denied. On parity, I am entitled for. My rights needs to be protected, my lords. In an earlier occasion, my lords, another writ petition was filed. That is at WP number 15615, my lords, pertaining to the very same tender period, my lords, wherein it is the same district task force committee persuaded me to withdraw the writ petition, stating that my 1.5 crores rupees penalty will be reduced to 1 lakh rupees on parity with other tenderers. And interim orders passed at page. I have produced at page number 109 the interim orders passed by this honorable court, my lords. No. No, I am not challenging any or relying on any undisputed facts. Only on admitted facts I am submitting, my lords. Annexure M may kindly be seen, my lords. So otherwise, maybe I may be relegated for revision, my lords. I'm in the meantime, my lords, let them not dispose of the sand, my lords. This, interim protection, let that sand not be disposed, not to me, my lord.
Because they.
Not
they are
to
liable
me.
to pay
My submission is, my lord, if it is
66
disposed,
lakh.
my lords, if I succeed in the revision, it becomes infructuous, my lords. Let it be, status quo may be maintained, my lord. Please, my lord.
Obliged.
This writ appeal matters, SL number 11, to T.M. Venkat Reddy.
Appearing on behalf of appellants, my lord. This writ appeal is under section 4 of Karnataka High Court and rule 27, my lord. The appellants are seeking to set aside the impugned order dated 15/6/2021. Here in this writ petition orders, my lord, they haven't issued the notice to all the respondents, but they have issued only to the government and dismissed the matter. You may see the order sheet, page number 32, my lord. On 2/6/21, the office objections is compliant, and then 15/6/21, the case is dismissed. The thing is, the appellants are landowners of 3 sites, my lord. And without the notice of the appellant, the WP was dismissed, even though the appellants have challenged the OS of 2005 in RFA 134 of 2021, which was apart from the government, there are around 12 respondents, my lord. Without issuing to them, they have dismissed the WP, my lord. In that WP, the petitioner had sought direction for sub-register, my lord, to affect the OS judgment and degree of the OS, my lord. The thing is, recently they have sold few properties. Yeah. The court ordered this. May I read out the?
My lord, a decree passed by the trial court. My lord, it has to be, my lord, incorporated in the encumbrance register maintained by the sub-registrar's office. My lord, it is a ministerial act which has not been followed up. My lord, when this fact was brought to the notice of the learned single judge, My lord, the learned single judge at paragraph 4 of the order may be seen, my lord, page 22. 22. Internal page 7 of the order of the learned single judge. Yes, after that, next paragraph, paragraph 4. Yes, my lord, and for that, the learned single judge has reserved the, my lord, it is at, my lord,
So,
page
page 15.
46. Forty-six, my lord.
The thing is, my lord, in OS. No, in the OS, they had colluded with each other and then they had obtained a decree and we have already. No, meanwhile, while this WP was pending, we had filed an RFA of 134 of 2021, suppressing the reality of RFA. They have obtained the orders, my lord, without due notice of other respondents. And they have. Yes, my lord, but using that, they have sold to other people also, my lord. It's not saying that it isn't stayed around. Much of it.
Number 12, Pradeep Saukar.
For the there's a delay of some 53 days. So what is challenged is order dated 27/9/23, the single judge, by which the writ petition was dismissed. All these things, the entire thing pertain to grant of, there was an agreement between the parties in respect of establishment of a hydel project. One of the conditions in that agreement was that we would pay rent of 1,000 rupees per annum. Please. We'll serve it on the advocate for the others.
Lord,
First
I take
respondent is
notice
served.
for respondent number 1.
Respondent 1 that has been, government has been served.
No, I have been, sir, but I take notice. Respondent number
First
1, my lord.
Second respondent, the contesting respondent. We'll serve copy on the counsel who appeared before the single judge.
Number 13, Mr. Vijay Kumar K.
Hearing for appellant, pass over the matters, Lord, please. Senior arguing one more matter. We engaged senior counsel, he is arguing one more matter, my lord. Kindly pass over, my lord. Land Tribunal, my lord, has challenged the grant made in favor of the respondent number 1. KT order, the order of the tribunal, my lord. Page number, there are 2 volumes, my lord. 242, volume number 2. Senior counsel will come. Pass over, my lord. Translated copy will start it from 263. page 263, translated copy. Second volume.
Before my lord, the Chief Justice, sir. Then he undertook the time whether to file a review before the learned single judge. ಮತ್ತೆ ಅದು ಹೇಳೋದು ಬೇಡವಾ?
Final order forthcoming in page 285, my lord. Operative portion of the order.
My lord, may I make one submission, my lord? My lord, on 26 February 2024, my lord had heard this matter for some time. And my lord, and then the appellant, my lord, took some time to take instructions to file a review of before the learned single judge. And the case was adjourned for that purpose, my lord.
Because the grant itself is not there. Now there is an order passed by the authority saying that there is no such grant at all in their favor. See the order questioned in the connected writ appeal. When this was pointed out, he said we'll file a review petition.
Well, we are not set review petition, my lord. Lord, I appeared before the court. Your lordship has asked me to show the order of the impugned order. I shown, my lord, it is coming from forthcoming page number. Your lordship may kindly look at page 57. Page 57 of the order. I read the portion of the page 57 is the order passed by the learned single judge. My lord, where I am reading this page 57, second line, my lord, third line onwards. Consequently, the respondent number 1, Honnamma, has failed to produce the relevant document to establish the genuineness of grant or sagu licit in her favor. I am view of that finding recorded by the revenue authorities, particularly Deputy Commissioner so-and-so, revision petition is to be confirmed in the result. My lord, for this, I stated that we have produced some document before the writ court only, and those documents have been not considered. Your lordship, at this stage, when the documents are available and record, your remedy is available before the very same court. That was the progress happened, my lord. At this stage, my lord, matter urgent, my lord.
3 authorities have held that there is no such grant at all.
Very same deputy commissioner has called for the original records, and wherein the Tahsildar has produced the certified copies regarding the genuineness of grant, and those records are available. The deputy commissioner, my lord, has confirmed. Yes, ma'am. Interim order make. Interim order was there, my lord, may kindly extend. Yes.
When, sir?
Connected matter, my lord, serial number 14, both are.
No, 13.1. 14 also.
13 point, sorry, my lord, 13.1.
Outdated.
14 June. 13 June, number 14 urgent, number 15, Mr. Rahul Dev, yes. Mr. Rahul Dev, yes. Still number 15.
My lord, here I'm appearing for respondent number 6 and 7.
Sixteen urgent, seal number 17. Mr. Munesh Kumar KV.
My lord, serial number 15, I am appearing for respondent number 6 and 7. The petitioner counsel has not appeared last time also. This is the second time. And as per CPC provision, it has to be dismissed, my lord. And I would like to make submissions also. The complete set of the documents has not been submitted to me till date. And the order single judge of the order of the single judge has been passed justly and rightly in compliance with. Huh? No, no, my lord.
Then why do you worry? Wait, let him come.
Let's sign.
But he has not served the copy also, but
Let him. In presence of,
next date,
yes, 4 weeks.
okay, obliged.
Let's I backed up serial number 17, I appear for the appellant.
17.
That's the direction issued by the learned single judge Millards to grant Millards TDR to the respondent number 3, the writ petitioner pleadings. I aggrieved I am before this honorable court. My submissions to my lords are, there is an inordinate delay, please, Millards, in having filed the writ petition. Because for the reason, please, Millards, the representations, Millards, were 2013, 14, and 15. And we had already issued an endorsement, please, Millards, indicating as to why the TDR could not have been issued to him. Second aspect, please, Millards, is he has voluntarily formed a road. Thereafter, Millards, he has handed it over to the local panchayat. The panchayat in turn gave it to the BDA. BDA formed a full-fledged road. Now that area came to us, please, Millards. So we have not acquired, please, Millards, any lands in question. Third aspect of the matter, please, Millards, as per section 14B, please, Millards, the TDR statute. Millards, TDR 14B, please, Millards, Roman 4, 1, 2, and 3, please, Millards, will have to be issued by us. There has to be a notification, please, Millards, requiring certain lands in nature. We have not issued any notification as on date, please, Millards. So therefore, question of, Millards, the BBMP granting any TDR, please, Millards, should not arise. On these aspects, please, Millards, I am before my lords. He has voluntarily formed a road, please, Millards, and handed it over to the panchayat. Says number 106, please, Millards, is his initial letter, Millards, to the panchayat, please, Millards, that he has found the road and handed it over to the panchayat.
You are for appellant.
I am for the appellant. He has issued a consent, please, Millards, to the panchayat. This is
Please, notice written.
let them not precipitate, Millards, sir. Let them not precipitate in such time.
Nothing at this. time.
My lord, I take
27
notice for respondent number
28
1.
June.
So very obliged.
Number 18. Sanjeev BL.
The Bangalore Mahanagar Palike is the appellant. Lord, we engage the services of Paura Karmikas through contractors. The point that is involved, my lord, is who is liable to pay provident fund contributions. The contract which we have, my lord, provides that the contractors shall maintain the accords and pay it. Lord, certain proceedings were initiated against the corporation BBMP, contending that you are liable to pay, you have not paid it. Lord, I must confess, my lord, that before the authorities, the fact of the matter is that this entire contribution has been paid, and we have produced records But I must confess, my lord,
Notice.
My lord, I appear for the respondent number one, my lord, I'm on caveat. In fact, my lord, I take notice for respondent number one, my lord, I'm on caveat. This matter, my lord, what had happened is that there was an order that was passed under the PF Act, my lord, under section 7A of the Act. That was not challenged at all by the BBMP. Our order was passed in 2017. Since that order was not implemented, my lord, we had approached this honorable court and filed a writ petition seeking for the implementation of that order. This honorable court, my lord, the learned single judge has passed an order saying that since that the order has not been challenged at all, there is in fact an appeal remedy available under it, which has not, there's no appeal that has been filed. Therefore, my lord, the learned single judge has passed an order to ensure the enforcement of that order. That's all that has been done, my lord. In fact, even as of now, the original order that was passed by the PF authorities in 2017 has not been challenged, my lord. There was a review file, that review petition came to be dismissed.
That's the only return.
Sorry, my lord.
Lord, in the meanwhile, what has happened is, my lord, after when the matter is pending before your lordships, before it would come up, they've issued an attachment order staying us from operating the bank account. My lord, I filed a memo. I've sought a stay of the order also, but I've sought, my lord, an application because BBMP account is stayed in, everything will come to a stop, my lord. My main operating account, I filed an IA, my lord, for permission to operate the account. It's not that I will go away somewhere, my lord, I'm a statutory authority.
On that they will consider. Your account is freeze pursuant to this order.
Yes, my lord.
My lord, my only submission is that the amounts that are due, which have been ascertained by the PF authorities, are in respect of the period from 2011 onwards, my lord.
That has been paid is our submission, my lord.
That order has not been challenged at all, my lord. So therefore, my lord, there is absolutely no challenge to that order that has been made. In fact, that is what the learned single judge finds, that given that there is no challenge to that order.
Where is that order of freezing the account?
My lord, I filed a, my lord, a memo on 3rd, an application under order 41 rule 5, along with, my lord, affidavit. Extra copy. My current account, my lord, maintained with Canara Bank, has been now, my lord, attached. I'm told the bank, my lord, pursuant to this has paid the money also. The irony, my lord, is that the contractors have paid this. I have filed an application with additional documents, which gives complete details of all the contractors.
Tomorrow, let us.
Please.
Number 19.
Then I favor appellant. Pass over, my lord. Then I favor appellant. Pass over.
Pass over. Pass over not possible. Some other day, after 3 weeks. Lot of matters are there. Yes.
After 3 weeks. December 20.
Preparing for the appellant, by virtue of this appeal, I am challenging an order passed by the learned single judge, wherein my petition for grant of back wages and full salary has been dismissed. It is a final order. As against that dismissal, I am before your lordship. The lordship may kindly find the impugned order at page 23.
Arising from labor courts.
Sorry, your lordship.
The petition arose from the award of the labor court.
No, Your Lordship, I am an officer in the
But from
administration of this honorable court.
My lord.
Query.
No, I am an officer in the administration of this honorable court. I'm an office attendant. I was suspended from service in 2010. There was a criminal proceeding pending against me. There was an acquittal. Now, after that acquittal, there was a 2-year time period that this honorable court on its administrative side took to reinstate me. Now, after reinstatement, I made a representation seeking for grant of back wages and full salary from the period of date of suspension till date of reinstatement. Now, that representation was rejected. As against that representation, I filed the writ petition before the learned single judge. Upon hearing all parties and pleadings being complete, the order has come to be passed, which I have challenged before Your Lordship.
My lord, paragraph 11 of the order of the learned single judge, my lord.
The sole ground on which the learned single judge dismisses my petition is because there is apparently a delay in me making a representation before this honorable court on its administrative side for grant of back wages and salary. Now, the reasoning in the impugned order, Your Lordship finds from page 32 of the writ appeal. Page 32, from the middle of the paragraph, that is where the reasoning starts. If I may just read out, Your Lordship. Page 32, Your Lordship has. Page 32.
Yes.
This is where the reasoning of the learned single judge begins. Lordship may see from the middle of the page. If respondent number 2, taking note of acquittal of the charges in criminal trial for lack of evidence, has formed its opinion that the petitioner is not entitled to seek monetary benefits for the period of suspension, this court is not inclined to interfere with the order passed by the respondent number 2 as per Annexure B. Having regard to gravity of allegations, respondent number 2 was justified in treating suspension period as a period of not on duty, and I do not find any reason in declining either payment of suspension allowances or full salary as claimed by the petitioner. Lordship may now see para 14 as rightly pointed out by the learned.
My lord?
Reply is filed.
Respondent number 2.
My lord, he is a watchman in the High Court of Karnataka at Gulbarga. My lord, he is a
No inquiry. In
my lord,
fact, there was
police
no
investigation conducted.
There was no judicial inquiry. In fact, that is one of my contention was.
Inquiry was never held.
Inquiry was never held. In fact,
So
I have.
suspension period was over.
Sorry, Your Lordship.
Suspension period was over.
Suspension period was over. I was reinstated into service. As on date, I am an office attendant.
And what is denied is the salary for the suspended period?
Sorry, Your Lordship.
What is denied to you? Salary for the suspension.
Salary and full salary and back wages for a period of suspension.
You are getting the subsistence.
No, I was
allowance.
not getting subsistence allowance also.
What is the period of suspension total? bill?
Your Lordship may take my list of dates on page number 1. On 31/10/2023, serial number 3 in the list of dates. 31/10/2010. That is when I was suspended from service. Lordship may next see serial number 7, 10/12/2015, I was reinstated into service. Therefore, a period of about 5 years is where I have been suspended. My respectful submission before the learned single judge was, for this period of suspension, full salary and back wages ought to be paid for the principal contention that there was no inquiry held at all. In fact, Your Lordship may please see my contentions have been recorded in the impugned order. It is on page 27. My contentions have been recorded. I have also furnished certain citations, certain judgments before the learned single judge. None of those citations or judgments have been considered in my respectful submission. This principal point as to the fact that no inquiry was held after the judgment of acquittal.
My lord, annexure B may be seen for a minute, my lord.
In fact, In fact, the state did not file any objections before the learned single judge. This honorable court on its administrative side filed their statement of objection. That as well I have produced in this particular writ appeal. Lordship may kindly see page 26. Page 26 of the impugned order. My contentions are recorded. Citations that I furnished before the learned single judge have also been taken note of. However, if your lordship were to see the reasoning in the impugned order by the learned single judge, which starts from page 32, none of my citations have been considered. None of my contentions have been considered. On one principal ground, which is the fact that there was apparently a delay in me submitting a representation before the respondent number 2.
Dismissed.
Your lordship, in my respectful submission.
Nothing, Mr. On
Your
the
Lord-
contrary, some soft view is taken against. it.
Your
Lenient.
lordship, the citations that I produced before the learned single judge, if I may just produce before your lordship, because there are certain legal contentions in my respectful submission. I'll just point out.
You are let off rather.
All of the citations I produced before the learned single judge, I'm producing before your lordships now. My principal ground is this. After the judgment of acquittal, there was no inquiry conducted at all. If your lordship were to see the citations that I have produced, lordship may kindly come to page number 2. It is not paginated. The lordship may come to the second page in the list of citations. The proposition is where a disciplinary proceeding post-acquittal in criminal proceedings are not conducted, then full consequential monetary benefits are required to be accorded to the concerned personnel. There is a decision or division bench decision of this honorable court expounding this very principle. Now, in my case, there is no inquiry conducted at all. I was acquitted on 1/8/2013.
In criminal case.
Sorry, your lordship.
In criminal case.
There was a criminal case that was pending against me. There is no difficulty in that proposition. There was an acquittal. There was an acquittal and the day.
So what is the period of suspension, total? Period?
5 years, your lordship, around 5.
5 years.
Around 5 years was the period of suspension.
Then we should have worked. You never paid subsistence allowance?
No, your lordship, I was not paid subsistence allowance. In fact, the learned single judge,
You stated in the petition. 5 years you did not receive any subsistence allowance.
No, your lordship.
Nor you made a grievance about it.
Your lordship, on 8/8/2013, immediately after the judgment of acquittal came out, I make a representation before the respondent number 2 stating, please reinstate me back into service. That was not done. Then on 10/12/20.
Suspended when?
I was suspended on 31/10/2010.
2010.
Please.
And acquittal is on?
1/8/2013.
1/8.
2013. Then I make a representation on 8/8/2013 stating, please take me back on duty. I make a representation on 8/8/2013, which is 7 days after the judgment of acquittal, stating, please take me back on duty. Now that representation is not considered, no order is passed. Then subsequently on 10/12/2015, which is annexure A in the writ petition, on 10/12/2015, an order is passed by respondent number 2 stating that I am reinstated back into service. However, the period of suspension shall be treated as such, in the sense that no back wages or no full salary or back wages are ought to be granted. Now then subsequently, I make another representation on 8/4/2019, stating that I have been conducting my duties as as a watchman. Kindly consider my request for back wages and salary. Now that was done on 8/4/2019. Now that representation is summarily rejected by virtue of annexure B in the writ petition. That rejection comes on 12/9/2019. Now both the rejection of my representation, which is dated 12/9/2019, and the original reinstatement into service, which is 10/12/2015, both I have challenged before the learned single judge as annexure A and annexure B. Lordship finds that at page 51 and 53 of the writ appeal papers. Now, challenging that, I filed the writ petition. The respondent number 1 state does not file any statement of objections to my writ petition. The memo stating that they have not filed any objections, I have produced that in this writ appeal. Respondent number 2, that is this honorable court on its administrative side, files statement of objections to my writ petition. Pursuant to which,
Here which judgment you are relying on?
please,
From your compilation.
Lordship may please come to page 17 of my memo of citations that I just furnished
That
before.
is
Page 15, sorry, page 17,
P. Ramaswamy versus Canara Bank.
please. If I may read out, the short question which calls for determination in this appeal is whether the employee on reinstatement after his acquittal is entitled to the difference in amount of full wages and the subsistence allowance paid between the date of order of suspension till the date of withdrawal of suspension. Lordship may next come to page 8, sorry, to page 20. To page 20. Lordship has page 20. Para 8. On reinstatement, the question arises whether the employee who had been undergone suspension is entitled to difference in full wages and subsistence allowance paid during the period of suspension. In some of the statute, it has provided with the employer is at liberty to pass appropriate orders regarding withholding the difference in the balance of the amount between the period of suspension. In case after acquittal, the employee is reinstated in service, then the employee is deemed to be in service for all purposes and further would be entitled to all consequential benefits. The bank regulations in the present case empower the bank to place the employee under suspension when employee is involved in an offense involving moral turpitude for which he is liable to conviction and sentence under the provisions of law. The employee can be kept under suspension during the period of trial. In case the employee is convicted, then his services can be dispensed with, and in case he is acquitted, the bank can institute disciplinary proceedings for the said misconduct. And in case the employer, after inquiry, decided not to continue the employee in service, he shall be liable for termination of services within 3 months' pay and allowances due thereof. But in case no further action is taken, or after taking departmental action, he is found not guilty, he shall be entitled to reinstatement and full pay and allowances minus such subsistence allowance as he has drawn and all other privileges for period of suspension. In this case, the
My lord, please, my lord,
sorry,
paragraph 13 of the order of the learned single judge, my lord. The reason why this has been withheld. Page 33, internal page 11, paragraph 13. He was appointed as a watchman of the High Court of Karnataka at Gulbarga.
I understand, there is no difficulty in that.
For orders on 11.
Sorry, Your Lordship.
For orders on 11.
Obliged, my lord.
One other aspect, Your Lordship. One of the other reasons why the petition has been principally dismissed is because there was apparently a delay in me making the representation before before the respondent number 2 is what has been stated in the reasoning of the learned single judge. Your Lordship may please find that. I will not take too much of Your Lordship's time.
We will
Lordship,
consider.
Lordship finds that at para 14, page 33.
Yes. We listed on 11th.
Great.
For orders.
Number 21. B. Vidyulata.
Appellant, my lords. My lords, the petitioners had challenged a memo, my lords, which is at page 56 of my appeal, memorandum of appeal, wherein, my lords, the representation of the petitioners was rejected. Your lordships gets it at page 56.
Page
56, my lords. 56, annexure A. 56. The petitioners, my lords, who are all assistant court officers, my lords, had arrayed, my lords, respondent number 13 as respondent number 2 in the petition. It was their contention that they were all seniors to him, but yet he was getting a higher pay because of the civil rule which was adopted in the year 2018. The anomaly, my lords, it was their contention was not set right by this honorable court by looking into the anomaly, because they being seniors were entitled to.
Will admit the appeal.
Yes, ma'am.
Or learned education students appeal is admitted. It will be listed for final hearing after 3 months. Delay is there, madam.
Yes, my lords.
So only notice written.
My lords.
Delay is there.
Notice, sir.
So notice returnable on 1st July. On that day.
Let it
On
be
that day,
listed in the earliest, my lords. Next month, my lords, anytime.
1st July.
Appearance matters, CC number 22, Mr. V. Ravi Shankar.
I appear for the response. Petitioners before your lords.
What is this contempt?
इधर है नंद इधर
Both parties.
It is interim order.
It's an interim order, your lords, they have not disobeyed. They have put up further construction to the 3rd floor extent, your lords, now. They put up till this 3rd floor, 2nd floor have been completed, now they gone to the 3rd floor.
Go before learn a single. We are not interfering.
The interim order was violated by them, your lords.
We are not entertaining contempt against the order brought under the contempt jurisdiction. Dated 1/7/21 is an interim order which reads as under. Vote this one. Full stop. Not only that the order is interim order, not determining the rights of the parties finally. Full stop. Liberty is reserved for the respondent to seek modification and vacation of the said order. Full stop. In the aforesaid circumstances, the court is not inclined to entertain the contempt jurisdiction. Post will be open for the complainant to approach learned single judge to seek modification, vacation of the order in accordance with law as already observed by learned single judge. The present contempt petition is dismissed, subject to above liberty reserved.
December 23, Mr. Kashyap and Nayak.
Pay for the complainant. Yes.
Pass over the matter against the senior counsel.
Contempt, what is contempt? Let us. My lord, it's more than 18 months. Effect has not been given to the directions of the learned single judge. Final order is passed. They file a writ appeal with several defects. Matter comes up. They don't argue the writ appeal, take time repeatedly. They're holding all my securities worth more than 100 crores. Full amount due has been paid to them. The learned single judge only said, whatever has been paid in excess, you refund it and return the securities. Now they are saying, at best, they are saying that whatever is paid in excess is not refundable. Even if that be so, that gives them no right to hold the securities because the amount is paid to them in excess. They are holding the money in excess. I don't have to pay, even if I lose the writ appeal, I don't have to pay a penny.
Senior counsel is saying,
Senior
held up in other court. Kindly pass over the matter.
Passover and after 2 weeks. Passovers will not be possible looking to the volume of the board. Yes. My lords, given the urgency, my lords may kindly have it next week. My money is held up with them. They are not returning. We'll take up next week, even 24th of June.
Next. Complaints in contempt matters, number 24. Trustee Anand.
Last date of hearing, I had made a submission that hearing for a petitioner in this matter, Lordship. We have filed the complaints affidavit on last date of hearing. They said that mutation entries, because the complainant is the church, the Archbishop. Now, previously, one PA holder of the Archbishop in the year 1964-65 itself, all these lands are alienated. Now, what we have done is, Your Lordship, I'm filing a memo on this date. I will also serve a copy on my learned friend on what date the mutations were effected and what is the basis and the documents of the mutations that have been effected. So what happens is, based on this, if there is a civil dispute, he has to approach the appropriate forum and challenge that orders.
So lands were transferred by whom? The church itself?
Yes, it's church by one person called Fernandez. One person called Fernandez, who claims to be the authority. And some of the lands have been transferred by virtue of an order under 48 of the.
File the details.
No, I have already filed the details. I have filed a complaints affidavit. My learned friend made an allegation last time saying that there are no mutation entries. So I have got a table prepared.
Pursuant to our last order you filed?
Yes, sir. On the last date of hearing, I filed a complaints affidavit. Now I am filing a memo, Your Lordship. I filed it. Your Lordship, to turn to page number 9, Your Lordship, which is a translated copy of the. The Revered Archbishop has filed this petition. But as per our records, there are different churches. And all these churches are being represented by one Mr. Fernandez for his executive title. So what we have done is we have prepared this entire tabular form of transactions that have occurred, date of transaction. And
This Fernandez is the
power of attorney holder
power
of
of attorney of the church.
No, my lord, no, my lord. The TV Fernandez is not connected to petitioner lordship.
We do not.
Please, we don't know.
How do we know? Then you file the suit for cancellation of the.
Yes, they have to approach appropriate.
Not your representative.
Lord, my
Today on the these are registered sale deeds.
Yes, your lordship.
These are the registered sale deeds.
Way back in
The
1964,
properties are sold by
65.
one Fernandez on behalf of the Archbishop.
he is no way connected to this.
We do not, this is contempt jurisdiction.
That's why may kindly have it on day after tomorrow. We'll go through the documents, lordship. Please, lordship. Kindly have it on day after tomorrow, lordship. Go through the documents. We'll go through the documents, lordship.
What is sold in 65, 75, 75.
And also some of them are orders under the Inam Abolition Act, because they were the tilling tenants against the church, under the church. All those are orders are available. We have supplied the records.
You come at 2:30.
Lordship?
Come at 2:30 after recess.
Please, please, lordship.
After recess. Nothing, there is nothing.
Number 25, Chandrakant R. Gole.
Petitioner in this. I filed a complaint, Your Lordship. I have not received a copy. They have filed a complaint affidavit. I have not received a copy of that.
You will get now, not served the copy of compliance.
We have not filed the complaint.
It's reflecting in the cause list, Your Lordship. They have filed a complaint.
Serial number 25, Your Lordship.
25, Your Lordship. Compliance affidavit dated 11/12/23 filed by the land AGA on behalf of A2, Your Lordship.
This matter, the civil disputes are pending. You also filed a complaint.
They have considered or not considered?
Yeah, we have considered it. And
No,
also,
Your Lordship. My name is not muted till today, Your Lordship. My representation is not been considered. Any
there is,
no
there is
orders
a,
have
there
been
is a
passed on my
proceedings pending before the Assistant Commissioner under 136(2). He has to participate there and out, after the outcome of that order.
TD Vishwanath, your TD Vishwanath.
Yes, Your Lordship. I am appearing for it.
His case is considered or not?
Yes, Your Lordship, it is considered
He says
endorsement.
he
of
has
the
to
issue.
make representation afresh.
Your Lordship,
Along
kindly
with-
turn to annexure R4, translated copy at page number 23, where the Tahsildar has referred the matter under section 136 subclause 2 of the KLR Act. That matter is being heard. His opportunity
I have
will be
not
given. He has to
received any
participate.
copy
in-
in regard to that, Your Lordship.
Where is your compliance? Compliance.
compliance
yes.
affidavit, Your Lordship.
It is there.
Yes, sir. Page 2 of the compliance affidavit, the order says the petitioner is permitted to make a fresh application along with necessary documents. Respondent number 3, Tahsildar Tumkur, is directed to consider the same in the manner known to law and take appropriate decision within a period of 8 weeks from the date of application.
That's order, Your Lordship.
After he has made an application, Your Lordship, that has been verified. And since there is a rival claimant for the same land, an endorsement is issued. And as per the KLR Act, he has a provision under 136(2) that he has to contest the matter before the Assistant Commissioner, who is the authority. And then he gets an order there and his name will be entered thereafter. So he has to participate
But
in
till
the
today,
proceedings.
I have not received any such type of an endorsement from a respondent in 2 or 1, Your Lordship. Even the compliance affidavit is not served on me.
I will furnish a copy of the complaint.
Page 26, page 26.
Now I have received the copy, Your Lordship. I leave
You
week
received
of
for
time.
date 2:30.
A week of time, Your Lordship. I'll just.
No, no, week time.
Or tomorrow, Your Lordship.
Even if you read 1 page a day, there is no 7 page. Where is the question?
No, I'll just cross check with that, Your Lordship. Then I'll submit to you.
Why? This is, everything is over except your.
Lordship, like, Like,
opportunity is being
I've taken
provided.
instructions, your lordship.
Material restriction.
Parties instruction. Parties instructions, your lordship. Tomorrow, your lordship. Kindly have it on tomorrow.
Tomorrow.
I'll follow tomorrow.
Tomorrow at 2:30.
2:30. Please, your lordship.
Non-filing matters in contempt, seal number 26. Srimati PC Vinita.
For complaint in this case, my lord.
The accused number. Complied with? What is it?
Lords, there was a direction for the accused number 1 to remove the ramps between the block A and the block B apartments and to give a pathway to the villagers and also to the movement for the residents. And now the pathway has been given to the villagers by demolishing the ramps, and also the accused number 1 has cleared the debris which were already there. Produce the photographs for your lordship. Also filed the affidavit.
Yes, Mr.
Yes, my lord. So just now I received this affidavit. I have not received any instruction from the complainant that they have complied the order of this honorable court. Just a week of time may be granted, otherwise 2 days. I'll see to the visit the spot, and next date it may be closed.
Complied with, they are saying.
Page 11 and
Just,
12 photos are very clear that the pathway has.
My lord, I've
Just
complied
2
with the
days of
orders.
time may be given so that
Where are the
in the next
directions?
date of hearing, it may be closed.
Where are the directions to be given? Page,
Second and third is from the corporation.
where are the directions of learning single?
Which is on
Page,
The accused number.
Accused number 1 should remove the ramp.
page 329,
page number 28, my lords.
same.
28.
The builder said the coordinate with BBMP obtain permission for reconstruction for demolition of bridges adhering to the norms of BBMP and application. So you have removed that gates.
Yes, my lord.
As on today, they have removed the debris and all, but the ramps of the walls were not removed. Just we need to see to that effect, whether it is affecting the easy movements of the villages or not. Just 2 days of time may be given. I'll visit the spot, and if everything is done, then we'll
My
file
lord,
our
my lord, one
affidavit.
submission, my lord. That internal.
Just 2 days of time. may be
Internal
given.
ramps, it is connected to the residents. They are no way
Oh, it is
connected.
as per the BBMP order, they have to remove.
They want only,
BBMP.
There is order of the BBMP, my lords, very clearly states.
they want to harass this, sir.
No, it's not an harassment. They have to do it as per the
They
BBMP
are not
order.
concerned with the inside apartments. my lord.
Otherwise, BBMP would not have ordered for this thing, my lords. It is very clearly stated by the BBMP, stating that they have to remove the ramps and the walls of the ramps
Lords,
also.
whatever the direction given by the coordinate
Yes,
bench.
where is ramps and where are those words? Ramps. So ultimately, the way was to cleared.
Yeah, way was to clear.
Way, and
We
also
have-
it is very clearly mentioned in the BBMP order that they have to remove the ramp and the walls of the ramps also.
We do not know. Where is BBMC? on
I'll just,
this? We are not concerned with
they have filed the
BBMC.
affidavit. BBMP commissioner has filed the affidavit by rejecting the application of the accused number 1.
Learned,
My lords, the affidavit dated 5/3/2024, filed by the BBMP commissioner, my lords. And it's in the last page of this thing, which is in Kannada. in the last page of the affidavit, may I read, my lords? ಈ ಮೇಲ್ಕಂಡ ಎಲ್ಲ ಅಂಶಗಳನ್ನು ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಈ ಪ್ರಕರಣದಲ್ಲಿ ಬ್ಲಾಕ್ ಎ ಮತ್ತು ಬ್ಲಾಕ್ ಬಿ
You are reading, but where is that? Which page?
the affidavit filed by the accused number 1 on 5/3/2020.
Where is that page?
They have filed it independently.
Affidavit dated.
We are not concerned with the affidavit of BBMC, we are concerned in.
No, it is the order.
Language of the directions of.
Yes, my lords. Just give me just 2 days of time. I'll visit the spot and will confirm that if order has been not complied or not.
Tomorrow.
So that, yeah, it's
Tomorrow 2:30.
Yes, my lords.
Affidavit, which have placed may be taken on record, my lord.
The affidavit of compliance filed by learned advocate Mr. Francis is taken on record. So learned advocate for the complainant wants time to be listed tomorrow at 2:30.
4, 24.
Petitioner, my lord. Morning session, they have given some documents along with some list of encumbrance certificates. My lord. I will take instructions and I'll make submission, my lord, because the lands belongs to the Archbishop of Bangalore, my lord. 116 acres was re-granted, my lord. I'll take some instructions and I'll have it next week, my lord.
Monday,
Please, my lord.
Monday 2:30.
Tuesday, my lord. Monday, Tuesday, my lord.
Tuesday.
Please, my lord. Bless. 2:30.
Number 27, Mr. Janardhan G.
The petitioner state in the writ appeal, your lordship. A week's time may be granted. There is some non-compliance amendment of the cost title.
This is
Pardon?
For the appellant state in this matter, your lordship. This is amendment to the cost title that we have to amend the cost title.
that it could be,
I will comply with that officer.
it could be disposed of, but to compliance of the order, that they have taken time for last 3 to 4 times. And
But they have preferred appeal also.
Yes, yes.
now
appeal is-
the question is this, matter is only remanded to reconsider, that's all. Kindly see the order. Against which they have come, the discretion is given to them to consider. Kindly see, kindly come to writ appeal, the order. I request to kindly come to page 27 of the writ appeal. There the impugned order is there. And last order is this. They have granted benefit from 2014 instead of from the date of appointment. The learned judge say under annexure K, having qualifications, she is entitled for the same, but consider that and pass appropriate order within 8 weeks. But that is all the only direction. Discretion is given to them to consider, but against which they have almost last 1.5 years, they are spending time instead of considering the same. Kindly come to page 37. Government, it also is referred in para 9, right, which according to them, they want to apply that, right, which is from prospective from 1/6 to 19. But my post has been regularized from the date of appointment, right, in terms of the court or dishonorable court order. Pages, page 37, right, order. Right, the two with the observation made in this court, the court, this honorable court has said, with the observation as made in the order, consider the case. May read that order. Your lordship, may the relevant portion would be from para 9, page 34 of the writ appeal, learned single judge's order, para 9, page 34. Now, the paragraph 7(4) of the government order dated 1/2/2011 reads as follows. From 1/6 to 19, the teaching staff who have not acquired the qualification so and so are not.
So you are only directed to reconsider.
That's all.
Reconsider. You will seek instructions and submit. We'll seek instructions.
Where is your appeal? Appeal is there?
Appeal is there.
We dismiss the appeal. There is nothing.
There are some office objections. Sure. 'Cause, 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 'cause
page, the learned single judge's order will at page 27, the relevant portions would be at page 34 and 37.
So you want from 28/12/93?
Yes, but that's from the appointment of this court order, my lord, annexure A. But they said the Lordship may kindly see the para 9 of the order, my lord. The learned judge clearly said they want to apply this 1, 2 to 11 order for applying UGC pay scale. But annexure K is clear, the qualification is prescribed which he is entitled. That is what the learned judge said. Para 9, my lord, page 34. They say from 111 to 11, 16 to 19 that UGC prescribed some passing of net and some refresher course what mentioned in that order. That is prospectively from 216. But the order has been issued from retrospectively from the date of the appointment. Annexure B to the writ petition. The kindly see at annexure B, the order for which they have a translated copy at annexure C, page 66 is the government order. In terms of annexure order, they have approved her post from 28/12/93, page 66. Now kindly come to annexure K also. The qualification is prescribed.
Your lordship kind. Not connected appeal
Before
is
that,
filed.
but just see annexure K, my lord. Qualification prescribed,
Connected
which
appeal
the
is-
learned judge has relied upon to pass the order. Kindly see annexure K, my lord, just for a moment. She had a qualification as on that date, or
Lord,
even according to their contention, she had a qualification.
No.
For that, the learned judge has, I'll just complete it, please. 1
No,
minute.
no, it is
Kindly
our
come to,
appeal is connected with the contempt. Lord, I pray for some time, Lord, because I'm handicapped, file is not there. It's misplaced. Your lordship may kindly have it next week, Monday.
Lord,
I would go
Lord,
on
she
with
is
the matter.
retiring for almost reaching for retiring age. Lord, from 1993, Lord, her post has
He
been,
wants to prepare himself.
Lord, this could be,
You have
Lord,
to argue your appeal also.
Yes,
Only, we, on remand, everything will be considered,
yes,
every argument of yours.
that's all.
remand.
Yes,
It is, that is what the.
learned single judge has said. Reconsider, the discretion is given to them.
Lord, there is,
Learned
on
single
the,
judge
on the
said-
last occasion, same, if I.
No, I
am
said so,
correct,
but
same
the
submission was made, I
court-
countered it on the last occasion, if we is.
But court
The
want of
order is-
time has adjourned it to today, my lord, that's all. Then the court never said anything about the merits of the matter. The court said we'll consider. Only a remand direction is given to them to
No, it is
consider.
not
matter.
only the remand, Lord, with a rider, Lord, in the light of this court's observation,
Yes.
the court's observation is at
Lord,
para 9. Therefore, there is a rider. If it is a consideration simpliciter, yes, Lord, we'll consider it. If my learned friend is agreeing for consideration of his request, simpliciter, yes.
Lord, they already considered that.
That
Why
is
should I come
exactly
to the
for the
court?
reason we have preferred an appeal.
Raised in this appeal by you will be considered.
Yes.
But for this, the observation made by the learned single judge,
Lord, that is in terms of annexure K. Learned judge has not said it is in terms of the government order. Kindly see, Lord, annexure K.
So in light of, my brother is rightly saying that in light of this court's observation,
that portion of the order we are aggrieved by.
No,
in view of the all contentions raised in this appeal, that shall be reconsidered.
Please.
Lord, why in terms of the learned single judge's order, annexure K, Lord, whatever the,
No,
Lord, this court, yes. But in terms of the, Lord, kindly see, Lord, their thing is, she doesn't have a qualification.
Normally, when the matter is remitted, it is open at large.
The learned judge has referred, my lord, annexure K, as on the date, if she having a qualification in terms of the government order annexure K, please consider.
the
Lord, what is
reliance
wrong in that,
placed
my lord?
on annexure K is not correct. That is why we have filed an
Kindly see
appeal.
annexure K, my lord.
Lord, the extension of UGC's care.
Yes. Kindly see annexure K, my lord, just for
And
my
as
learned
on
friend
the
is
date
raising
of
all the
appointment,
objection.
the-
Kindly see, my lord. Kindly see annexure K, my lord. page 89. Lord, kindly, Lord, that order, after that ED, Lord, order, Lord, government para 4, Lord, may I read just. Lord, government are pleased to extend UGC pay scale of pay to the teaching working in the aided colleges education in the state with effect from 1st April 1993. The scheme of extension of revised 1986 UGC pay scale to the teacher of the college education shall be as follows. Coverage, date of effect, clause 2, minute. That is from 1st April 1993. Not kindly come to Roman 3 down para 3 after para 3, minute. The scale shall be extended only to those persons who have the qualification of BA, BSc with MEd or MA, MSc with BA, MSc with BA, BEd and MEd. Then they say second one is another class 4 is lecturers in the College of Education who are to be recruited in future should be possess the following qualification or the qualification prescribed by the UGC from time. Both are there, qualification or the prescribed by the UGC. Now they only stick on to UGC. But kindly come to annexure email. What is my qualification as on the date?
Monday.
Wednesday.
Thanks.
December 28.
Monday,
1 PM.
Monday. Date,
20, next Wednesday.
Wednesday, 12/6. Number 28.
My lords, the complainant had filed a writ petition seeking order directing the DC as well as the Tahsildar to conduct Podi and Hadbust and then to issue Lebanese sketch, my lords. The order was made on 24/3/2022, my lords. The respondent are filing the complaints affidavit today, my lords.
Will you please use mic so that?
Yes. Previously, also in the same survey number, such an order was passed. We have issued an endorsement to them, which they are also aware of that. And similarly, the complaints affidavit is filed. And they are satisfied with that and they will approach the authority because there is a discrepancy in the RTC. With the discrepancy, they cannot conduct the podium. The endorsement has been issued. Complaints affidavit has been filed and it has been served on. Previous contempt has been dropped, Your Lordship.
Contempt 651 of 23 was disposed in the same manner, my lords.
Decided or not decided? Decided, Mr. Shaffer?
Yes, sir.
Decided or not decided?
Decided.
Decided. Where is that? Page 6.
Lordship could kindly see page paragraph 5 of the complaints affidavit, Your Lordship. Similar order which was passed in same survey number, a complaints was dropped.
So it is complied with, madam. What is wrong?
They are satisfied with the compliance.
Yes, my lords, it may be disposed of in the same manner. my lords.
Donated, full stop. Following what the directions issued by learned single judge required to be compliant with. Page 14 of the orders, 1 and 2. Today when the proceedings come up for consideration, additional government advocate Mr. Jaffer. There is compliance affidavit. Copy of which is given to learned advocate. Complainant Miss so and so so and so. Learned advocate. With complainant informs that the order under contempt is complied with. In that way, paragraph, the contempt proceedings are closed and disposed of. Notice is discharged.
28.1 also the same case. 28.1 also similar case. Same survey number.
649. So this was which? Earlier was which number? Serial number?
So 60.
28.1.
28.
28.1.
And now? So what about 28.1?
28.1 is similar matter, same survey
Survey-
number, same.
Same, so
different-
same order?
Yeah, same order.
Same order.
Different path.
28.1 same.
December 29. Mohammed Zulfikar Ahmad.
Represent the complainant, my lord.
Your Lordships, we have filed the wakalat today morning, Your Lordships. Your Lordships may kindly grant a short accommodation to file the reply.
Matter involving the husband and matrimonial dispute, my lord. Matrimonial dispute between the husband and the wife, my lord.
Matrimonial.
Matrimonial, yeah, what has happened, my lord? They, in MFA, my lord, the wife has agreed to execute Khulanama and get the same decree from the Honorable Jurisdiction Court. But instead of complying, my lord, what they have done, my lord, both of them filed a joint petition for divorce as a plaint, which came to be dismissed as not maintainable. My lord, at page number 74, my lord, if your lordship could kindly turn, my lord, page number 74, my lord. Shall I read, my lord? Page number 74, point number 9, my lord. Both the parties hereby agree and undertake that the appellant number 1 will obtain Khulanama and get their marriage dissolved, seeking a decree of divorce from the jurisdictional court. My lord, if I don't take divorce from the jurisdictional court, my lord, because many records, the name of the complainant is mentioned in passport and other records. On the basis of Khulanama, they will not get the names deleted. Only a jurisdictional court order only can help me in getting this. All the other matters have been settled, my lord. Only this particular matter is not settled. That's a most humbly pray the other side to cooperate so that file.
So this.
Even though, my lord, one submission, can I interrupt, my lord? Can I interrupt, my lord? If you files a petition under section Dissolution of Muslim Marriage Act 1939, my lord, it will suffice the matter, my lord.
You are not abiding by your own agreement, terms of agreement.
Your Lordships, we filed the wakalat today. We received the file very recently, this week, Your Lordships. A short
My lord, on
accommodation may kindly
28/3
be granted.
only, there was an order, my lord. 28th of March only, there was an order, my lord.
Mr. Counsel, there is nothing to be subjected to contempt. Where is the direction? Only agreement is there. Court has not directed anything.
My lord, they have to approach the jurisdiction court and help in getting me judicial decree of divorce, my lord.
Understanding between you.
Yes.
We can't enforce any direction from this.
In the Khulanama, what, my, this thing will not get this thing, my
Where
lord.
is the direction which can be enforced in the contempt jurisdiction? Which direction?
My lord, in the annexure.
Still the council said that they will see to it that.
Okay, my lord, agree.
When
Much.
do-
A week's time, Your Lordship.
Next.
Third, 1 week, one
11.
date be given.
Not 11. 13.
13.
16 June.
Much obliged.
December 30. Vidulata.
Page 23 is the directions of Division Bench of this Honorable Court, my lords. It is a matter of compassionate appointment, my lords. The mother of the complainant had died, my lords, in the year 2017. An endorsement was issued, my lords, as per page 24, stating that she is not entitled for appointment as per sub-rule 2 and 3 of the Karnataka Civil Service Compassionate Appointment Rules, since she was a divorced daughter. This is fairly covered, my lords, by a decision of this Honorable Court. Your lordships have passed an order in similar matter, my lords, holding that
Yes, what do you do?
This is the case where, Your Lordship, the order that is passed is prospective. Now, on the day of the death of the mother, the rules, the CR rules did not provide for a divorced daughter. Your Lordship. So it is the order, it's a Supreme Court judgment is there, Your Lordship.
this order, your lordships have passed.
But there is no appeal, you have to comply with either way.
There is no appeal.
There
There is no appeal.
In this, the decision has to be taken, the CAR rules have to be amended for this, to accommodate this, in terms of this order, Your Lordship. That decision the DPR has to take.
This has gone to Supreme Court?
No, that, I don't think yet it has not gone.
So this is a part, this is the contempt matter, Mr.
Yes, sir.
So even the law is that we have held that in this case that
I will file my reply. Your
on the day of consideration of the application, whatever is prevalent will apply.
And even at page 11, Division Bench of this Honorable Court, my lords, is held, holding that the amendment is applicable since the original rules were struck down, even in this matter, my lords. And that they're issuing.
However, if the benefit has to be given, that decision has to be taken by the DPR and by the government. The matter is
We are
pending.
not here to consider the arguments, Mr. This is for compliance.
I will file my reply, additional affidavit to this. Already filed a compliance affidavit in that regard. I'll seek instructions and file my reply.
Directed to consider the case of the respondents for appointment on company grounds
Yes.
and merits in accordance with law.
Yes.
If she is otherwise entitled to.
Page 18, my lords, para 11, this aspect, what my learned friend is arguing, is considered with the division bench, my lords, of this honorable court. Page 18, in page 6, para 11. Thereafter, the Karnataka Civil Services Appointment.
This is
rules-
same, identical.
Identical. But here they hold that it is by substitution and hence it is retrospective.
So here is a married daughter or widowed daughter?
She's a divorced daughter.
Divorced.
Divorced in the year 2008 itself, similar to,
The facts are completely different, Your Lordship. I will seek instructions.
Whatever, then you are not preferred appeal, Mr. Thompson. Why don't you appreciate? You have to comply with.
she's just a group D employee, my lord. She's a, and it's
Time will be
not as if,
granted,
it's not as if
A week's
she's
time may be
divorced
granted,
just
Your
then.
Lordship. I will seek appropriate instructions. I will submit to the court. A week's time may be granted.
No, you comply with. Fixed time will grant not for any other. purpose. Not for whiling away the time.
From 21/9/2023 itself, my lords,
Learned additional advocate government, Mr. Jaffer. Fix time. Setting that within a week. Stating that within a week, the orders will be complied with.
No, we'll file reply. Appropriate reply. A week's time may be granted. Your Lordship. We'll come back and we'll say.
So
It may not say that.
within a week time will be complied with.
Because the orders has to be passed with the government, Your Lordship.
Have to pass the order.
We will.
Quickly work. How much time will need? Stroke of one, stroke of pen. Otherwise, we'll call for the person concerned. We'll
Should-
receive the
one-
complaint,
one
we'll
week's
receive.
time may be granted.
It's exactly
Yes.
similar and identical to what is held by us recently. So double contempt.
A week's time may be granted, Your Lordship. If it
Weeks
can be
granted.
completed.
So we are recording that learned so and so states that within a week's time, the orders will comply. Or you are seeking week's time to comply with the order. For what? You must mean, knowing that why you are seeking.
Your Lordship, this, if Your Lordship could kindly read the complaint affidavit filed by the state. It is said in this, we have mentioned the judgment of the Honorable Supreme Court where it has said, decided on November 8, 2003, service law appointment, compassionate appointment, retrospective applicability of norms, policy, impermissibility. Held for appointment on compassionate grounds. Policy prevalent at the time of death of the deceased employee only is required to be considered, not subsequent thereof. Here the case is that the amendment has come subsequently. That is why the decision has to be taken by the, that's why we are.
We do not know where to comply with. That's all. We are in contempt jurisdiction, Mr., not in appeal.
Yes. We've already considered and we already issued an endorsement in this matter, Your Lordship. Along with the complaint affidavit, compliance affidavit, we have filed the endorsement dated 16/11/2023.
Which would make the contempt more grievous, my lords. That's what I submitted last time.
You filed compliance affidavit?
Yes, Your Lordship.
Complaints affidavit where they have stated the exact reason which this honorable court said, no, it is not applicable. They have, that's why I made a submission that the contempt is more grievous in nature. That's why they took time to comply with the orders last time. It will be more grievous, my lords, when a director, my lords, sits over the judgment of this honorable court, a division bench, and says the same thing again. Repeated filing, they're forcing us to file repeated cases before this honorable court.
But we have filed complaints of debate and 51, 26, last night kindly said it.
Complaints.
So within 10 days, you comply or bring the officer? No.
Kindly tell us the endorsement.
We have seen, Mr. P.
Endorsement also. Refused submit staff. Authority after referring to the
Now you look at your interpreting the rule, last paragraph of page 8 of your endorsement. As such, there is no provision in the rule for appointment of divorced daughter of a deceased government servant. Now it is there now.
now,
That is the whole
cannot be
point.
applied, not retrospectively, is the contention of the.
So that is the judgment now we have delivered. So the directions regarding compensatory appointment as given in the judgment and order by learned single judge brought under this contempt jurisdiction shall be complied with before next date. If not complied with, who will remain present? The Director, Health and Family Welfare Services may remain present. Who will have the option to remain present? The video conference. Online. Online. When, Mr.
Next Thursday.
Next Thursday, 13.
Greatly obliged. It's number 31, to Joseph Anthony.
For the complainant, your lordships.
Lord, a week's time may kindly be granted to comply with the order, my lords.
Week's time.
Week's time, my lord.
Obliged. Number 32, Mohammed Tahir.
For the complainant.
We have
accused to conduct, issue notification for the conduct of elections to the Jilla Panchayat. The term expired in the year 2021, 5/2021.
21.
Please, they have not issued the notification reserving the post for the conduct of elections.
We have filed an application that we're seeking time, your lordship, because of the model code of conduct and assembly elections as well as the parliament elections, your lordship.
You are Mr. not audible. Have a mic in here.
We have filed a compliance affidavit in this matter, your lordship.
Adhyaksha and Upadhyaksha. of
Yes.
Jilla, not Jilla Panchayat.
Only the rooster for the Adhyaksha and the Upadhyaksha.
Now, when will get the rules approved?
Immediately.
Rules have to be- rules
Yes,
have to be
yes,
approved.
yes, your lordship.
New rules.
Yes, yes.
So when will be?
4 months' time was requested in
Will
this.
approve it?
The Department of Rural Development and Panchayat.
Get it done.
Yes, your lordship. That's why we have sought for 4 months' time in this matter. Lordship, the other matter, serial number 4 is for
You come on 24th with instructions as regards the time limit within which we'll get the rules approved.
Yes, your lordship.
To be listed on 24th, on which date learned additional government advocate shall instructions. Full stop. These contempt applications will be listed with CCC number 534 of 20. 2024.
The other matter also is similar.
33.
Same matter, pertaining to.
33 also same.
Yes, sir.
So 33 to be same order.
Yes.
Number 34, Mr. Shivraj MK.
Millard, I'm for accused Millard. In short, a week's time Millard to file my affidavit Millard counter.
Time.
A week's time.
Directions of the learned single judge in page 12, my lord. The order. Page 2. The third respondent is directed to register the kata subject to verification with regard to genuineness of the or otherwise of Akkupatra produced at annexure A by the petition within a period of 2 months from the date of receipt of this order.
Second July.
Number. So, premiering ready notice matters, number 35, Mr. Chandra Tarika K.
Petition. My lord, the order rejecting an application for extension of the lease period is questioned in this. The facts are these, my lord. The mining lease was issued on 26/7/2002. my lord. That is for a period of 20 years, which would expire on 25/7/2022. My lord, in the year 2015, there was an amendment to the act by which all the subsisting mining leases automatically gets extension up to 50 years. That is section 8 capital A of the act. My lord, an application came to be filed, which came to be rejected on the ground that there is a lapse because 2 years mining operation was not conducted. Therefore, there is lapse of mining lease. Therefore, extension was not granted. My submission is, my lord, may kindly see the order now, the order, present impugned order, which is found at page 187. It starts at 187. Lordship may kindly come to the relevant portion of it at page 200, paragraph 47. Page 200, my lord, paragraph 47. My lord, referring to the lapse, it is held that the mining lease of the revisionist is not entitled to deemed extension on account of violation of lease condition for conducting mining operations beyond the area of lease granted under the mining lease number 2368 as established by the Supreme Court appointed joint team, and also on account of the fact that the lease of the revisionist has suffered a lapse for remaining idle since 18/4/2013. My lord, 18/4/2013 lapsing is due to the judgment of the Supreme Court suspending all mining operations in the Bellary district, my lord. Now, there is such an order is passed, then the lease will not automatically lapse, is my respectful submission based on Rule 28. my lord. Rule 28 of the Mineral Concession Rules. That refers to lapsing of leases. May I read? my lord, please? Mineral Concession Rules 1960. I may be permitted to read the rules. Subject to the condition, Rule 20. Subject to the conditions of this rule, where my,
What is this case?
Case is a case of lapse lease. The apex court in Samudaya Parvatana case not categorized this particular lease as category B leases because depending on the rate of violation, the apex court has categorized the leases in 3 districts of Karnataka as category A, category B, and category C. So far as category C leases are concerned, they have been cancelled. For category A and category B leases, the committee not appointed by the Supreme Court suggested for reclamation and reopening plan, RR plan. And as per that, this particular lease was also recommended for RR plan. Since they have encroached 15.43 acres of land in violation of the lease condition, and they have failed to pay the penalty also to that effect. From the year 2030, this lease remained idle. But they have not taken any action for claiming RR or reopening the lease. By the virtue of the Rule 4A, if the lease is remained closed for more than 2 years, that lease becomes lapse. Therefore, the competent authority invoking Section 8A passed an order that this is a lapsed lease, deemed extension cannot be granted.
File reply.
I have filed the reply. But kindly peruse the order of the
reply is not filed.
Page number 198.
For this reply is not yet filed. To this writ petition, reply is not filed.
We have filed the reply.
File the reply,
On
statement of
8/8/2022.
13296. Yes, statement of objections filed on behalf of 326.
I'll find out, my lord.
You don't have?
I don't have the copy.
Get the copy.
Maybe 2 days, 2 days.
Get the copy. 1st of June, 1st of July.
Number 36.
That's 36 and 36.1, I represent the petitioner's counsel. This is a case, my lords, where in an auction, my lords, I participate. But what happens is the bid, my lords, is on the percentage of the mineral value. My lords, according to us, it's an online portal. Technical bid, we succeed, my lords, in the technical bid. Then whoever is qualified, we have to give our bid for the price, my lords. Reserve price is fixed as 35%. Now I take it to 65%, but the online, the portal, my lord, converts that 65% into 2,400. So 2,400% is what is quoted in the second round. That is the second round is taken into consideration.
What is your prayer?
Lords, one is they have forfeited about 17 crores of my guarantee amount, my lords. And moment MSTC informed me.
Why
that-
it is forfeited?
Lords, because what happens, my lords, in the bids, we have to show the floor price is fixed as 35% of the reserve price. Then, my lords, we have to give over and above the mineral values calculated on percentage wise. In an online portal, some of us are qualified in the technical bid. I put, my lord, 63%.
That we have seen, but then what is the logic in forfeiting?
And my lords, they have again auctioned and they have sold the mine. I have no issues. But in the first matter, it is 16, 17, almost 16.89 crores. The connected material, same day, my lords, 63% is converted as 2,400% in the entire history all over the country. There has never been, since, my lords, I am in the mining industry, that 2,400% it will never get converted. And moment I was told, I told them, this is a mistake. 63% has been converted into 2,400%.
So annul the tender process, cancel the tender process.
And then they held.
On right ground or right or wrong, whatever ground. He said there is a technical glitch because of which this value was shown. Now, what is the difficulty in refunding the?
That is one of the conditions, because there are unscrupulous bidders, Lord. They will quote higher rate. He is not the first time bidder. That is what
Exactly.
our statement of objection we have contained. Since the value is high, in order to derail the very auction process, Lord, there are people. They'll quote
So where is the clause for forfeiture?
18.1 statement of objection and respect.
Not the tender doc, we have referred to it.
Class 18.1B.
We have produced that, my lords.
85 page.
Let me kindly take my statement of objection.
Page number.
Yes, sir.
15.111 in the writ petition, we have produced that. 15.7.
Page.
Page 6. Page 6 of the state.
Statement of objections, 38. 6. Okay, 6.
So then you are admitting that it was a technical, because of technical flow, this 1124 will reflect.
That is his contention.
And the day, what happens is MSTC informs us, moment we submit our bid, 25th of March, they inform to me and others that the floor price, that is the highest floor price after the reserve price is 2,400% on 25/3. Within 15 minutes, I write to MSTC and others saying, you have shown it as wrong as 2,400%. It is 63%. Please rectify even before the second round commences. That I have produced documents. On the same day, within 15 minutes, if I have indulged in a corrupt practice, my lords, why will I write it? And in the history, there is none, my lords, I can go to 300, 400%, but 2,400%, and they have re-auctioned the mine. They have not received more than 70% subject to correction.
Are you disputing that initially 63% was?
Yes, we are disputing. They have entered 2411%. Then they have turned back and said, no, it is not 2411. There is some mistake. It is 63%.
Lords, we have said 63%. Lords, we have given the calculation also. If you take 63%, the value in rupees will be 2,400.
You show some application, etc.
Lords, please come to 251 for a moment. Lords. The day the price was shown to us, 251, Annexure L, my lords. That was the e-auction notification. The price, my lords, was intimated at 4:20 PM. The floor price in this clause 2, my lords, it was informed to all the bidders, including us. Clause 2 therein. The floor price for the second round of e-auction is 2,400%. Your lordship gets it, my lords. Immediately on coming to know, and please see the auction, date of auction was 27/3 at clause 4. The date of auction is 27/3/2023. Time of auction 11 AM to 1 PM. The lordship gets that. Immediately on the same day, lords, we address a mail with attachments. Your lordship should get at 2:69. Within 2 hours, I address a mail to them. 269 on top, your lordship should get. It's a trailing mail, my lords. And then the next, I give the screenshot of what I have shared. Then, my lords, I give a hard copy of it saying that we have submitted 63%. It is converted as rupees. If your lordship converts that 63% as per their own value, it becomes 2,400. That rupees has become percentage. And 17 crores is now for, Lord, the second auction, if that was the case, second auction also should have gone at 2,400% of the value of mineral. If the value is 100 rupees, my lord, nobody will agree to pay 2,400 rupees and buy from the state. And I can understand if I had committed a fraud. Same day, within 2 hours, I tell them, this is a mistake in your system. Please correct it to 63%. At page 272, your lordship should get.
The fresh round you anticipated?
We did not, because, my lords, I have already lost 17 crores. They just forfeited. I gave representations, I've explained, I've given material, screenshots, everything. And calculations have set out, my lords. If your lordship sees the calculation also, that is what has happened in the system. The lordship comes to annexure B. We have given the calculation at page 35, which is also set out, my lords. How that 63% translates into the price which they had quoted was 3,826 as per their calculation per MT of iron ore. Now 63% would be 2,400. Now 2,400 is taken as the percentage itself.
Difficult to undertake that exercise of.
But I have written, my lords, I can understand if I had delayed it. Within 2 hours, I write to them, even before the auction commences, it is 63%, not 2,400%. And that, my lords, I can understand if they had, my lords, forfeited some EMD or something. The entire bid security amount of 16 crores is totally forfeited.
In order to recalculate as per the of the there is no human intervention here. It is all system generated.
And when I say there is a technical glitch, they simply say, we have considered, according to us, there is nothing. The reply endorsement is at page 31.
Where you are disputed? Where you are disputed?
Submitted that initial price offer. All technical work. Submit the initial price on 24/3/2020 and next forward action. basic for out of them, EQT for basic to run. Top 6 bidders are qualified who are allowed to participate in the forward action. The highest IPO for the back as per MSTC platform, this is a platform, is 2411% submitted by the petition. Further, the highest IPO will become the floor price, initial price for the forward action. During the forward action, as per schedule on 27th, no bids were received and auction process was annulled at the applicable floor price 2411% submitted by the petition. It is submitted that the respondent number 2 court will be submitted as per clause 18.1. B on B and 15.7 of the tender document. The said clause 18 we have extracted, which clearly provides for forfeiture of section. Then para 9, page number 7. It is submitted that the state government forfeited to the security of the petitioner as per the provisions of the tender document. The petitioner has failed to offer at least one final price in the forward second round of the action. Therefore, the entire action process was annulled. Hence, the state government issued a notice to the issuing of bid securities and then forfeited the bid security and the payable and the began. It is submitted that the petitioner addressed a letter dated 25/3/2020, respondent number, stating that we have submitted 63%. This is for the first time. Page 7. Page 7, paragraph.
Page 7.
Page 7, paragraph. It is submitted that the petitioner addressed a letter dated 25/3/2023. The respondent number 2 stating that we have submitted 63% as our bid, a copy and so on. But as per email received from MSTC Limited, it is 2411%, a copy and so on. Hence, it is requested to update our offer as 63% on MSTC portal. The respondent number 2 examined the said letter dated 25/3/2020, received on 27/3/2020 and verified the same.
difficult for us in 226.
Lords, all that I'm saying is this. They could have considered my representation. They have anyway forfeited. I've given every, Lords, if it is a fraud which I have committed, what my learned friend wants to, that we participate just to make a auction failure. Now, the date I am intimated about the floor price, that is the date when every auction person's bidders were intimated. I've immediately written them within 2 hours saying that please revise it. It's a technical glitch. I've given the screenshot. They could have considered that. They don't say anything, but they say we forfeit your amount. The auction was on 27th. 25th, they intimate every bidder saying that the floor price is 2,400%. Moment I come to know, I said it is not 2,400%, please, it is 63%. Please revise it to 63%. And every bidder would have participated, including us. Because it is 2,400%, nobody participated. And they have re-auctioned it. And if my learned friend could reveal the rate at which it has gone, my lords, your lordships will see that it is not even, it won't go more than 200% maximum. They can at least reconsider the issue, my lords. I can understand if I had, after it is all done, I come to the court or I go to the authorities.
I kindly appreciate the letter also submitted by the petitioner dated 25/3/23, issued by the authorities
That's
only
right.
on 27/3/23.
No, before that,
Second round.
My learned friend, I pointed out, please see 269. I pointed out, email was addressed.
Now,
269, my email is addressed. My learned friend has to see that. Email is also a communication. Email is given on
269. Which page?
in my statement of
Statement.
statement, it is clearly stated.
Paragraph
Paragraph 10.
10. Yes.
The last line. The respondent number 2 examined the said letter dated 25/3/2023, received on 27/3/2023, and verified the same in the office.
Please come to page
That is
269.
27/3/23 is the second round of call.
Correct. But please see 269, my lords, the email addressed.
And
That's a hard
if
copy.
at all something is there, not against this order, they have to approach the revisional authority under 30, because they are in a position to examine on what
Lords,
day.
with great respect, it is not under 30, that's under MMDR Act. Please see 269 for a moment, my lords. That's what I pointed out. Email is addressed on the same day. My learned friend refuses to see the email. Submission. 269 email ilva. Order.
We'll defer this. We are afraid that we can do it in late jurisdiction. Or July, let us think. If you want to approach the authorities, we can right now for this.
Lords, we have given that. One of the prayers is we have given representation, let them consider. Because, my lords, I can understand if I had delayed and approached them. Within 2 hours, I have approached them saying that is a glitch. Email is dated on the same day to Director of Mines and Geology and
on next day we'll pass some more.
Please.
Player 2 and 3 is consider their representation. That is about without disturbing the order of the authority. Yeah.
You are will be happy with the grant of prayer Romans 2 representation.
Yes, without having any influence on the earlier order, because then they should not say it's already rejected, so there is no consideration at all.
On that I will appropriately word that course will adopt that. Let it be earlier rather than, so that other will forget the thing.
Yes.
18th June.
Please.
Nineteen.
Please.
Still there.
Thirty-seven.
Yes.
My lord, through the present writ petition, I am seeking for setting aside a survey sketch that was done in the year 2016-17, my lord. My lord, as a brief background, my lord, why I am attempting this, my lord, is, my lord, the petitioners actually engaged in the business of mining, crushing and quarrying of mines and minerals, my lord. My lord, to the effect, my lord, that consent was given to him that the land that was proposed, wherein for his license for carrying out such activities, was outside the purview of the eco-sensitive zone in Tamanayakanahalli, my lord. My lord, may take the second volume, my lord. My lord, second volume, annexure H. At the relevant page is 203. My lord, may I read?
So what is the case?
My lord, I have been granted the license for carrying out quarrying activities on the basis of the reports that were given that the property that I have chosen falls outside the eco-sensitive zone. My lord, what has happened, my lord, in the year 1915, the then Maharaja of Mysore, my lord, for the purpose of identifying the boundaries of Mahadeshwara Reserve Forest, which falls at the boundary of Karnataka and Tamil Nadu, had issued a notification, my lord, which is at annexure E, page 171, in 1915, my lord. page 171, annexure E. My lord, my dispute is limited to the boundaries that are identified for the east portion, my lord, which is at page number 172. My lord, I'll have to take you through the village map simultaneously, my lord. But the sketch which has been drawn, which is the impugned sketch which I'm seeking setting aside of, is at annexure F, my lord, which has been drawn in tune with this 1915 map after a period of 100 years, but not in compliance with the directions given by the then Mysore Maharaja. It's at page 182, my lord, the sketch which is what is under challenge.
Map.
Is the survey sketch 182, which has been drawn. My lord can see sketch showing the survey and demarcation of the Mahadeshwar State Forest, an additional area in Arnical Wildlife Range, Bannerghatta National Park, notification number so and so, dated 2011-1915, during the years 2016 and 2017. My contention over here is whatever has been directed by the Mysore Maharaja has not been followed while conducting the survey and marking of the points. Because of which, my lord, if we go through the east portion, my lord, I will take you through it. There are only 4 points which have been marked for identifying the boundaries. But so far as the present sketch which is concerned, there are 25 points. And because of this, my lord, the area which I have chosen and which has previously been also identified that it falls outside the eco-sensitive zone, now has been identified to fall within eco-sensitive zone, and my application has been rejected, which also I've produced at annexure V and V1.
No reply is filed. Then I'll reply.
Prayer itself is fake, and they are seeking to pass, setting aside proceedings of Maharaja of the year 2011-1915 in the year 2023.
My lord, if I was doing that, I'll be a little more adventurous. I'm not setting aside. I'm not even contending that the 1915 proceedings. I am saying that the survey which has been conducted improperly, which is not in consonance with the 1915. I'm not seeking setting aside of the 1915 proceedings.
May I read the prayer, page number 25. Writ petition seeking writ of mandamus or any other appropriate writ or order for setting aside the impugned map produced at annexure F,
Which is the survey map of 2016-17.
being not in consonance with the directions proceedings dated 2011-1915 issued by the Maharaja of Mysore produced at annexure E, as also village map produced at annexure B.
So I'm not seeking setting aside of the village.
Let me submit or else you. Setting aside impugned map proceedings and the sketch and the village map in a writ petition or under 220. And the fact of the matter is now MOEF has issued a notification delineating the eco-sensitive zone of Bannerghatta National Park, wherein it is clearly mentioned this particular area is within the eco-sensitive zone. I am placing the notification.
Then put it on record so that we can deal with it.
One otherwise, prima facie it is not.
You are right, but.
My lord, my only thing is I'm setting aside of annexure F, not of the proceedings of 1915 or the village map. That is too adventurous.
According to you, what is the reason for filing this petition?
Because we have rejected their application for quarry license on the ground that it is within the eco-sensitive zone. The short point is whether it is in the eco-sensitive zone or not.
So what
I am
is-
producing the notification.
I don't have my, no, the same notification has already been produced by me, my lord.
Is the notification of year 7th March 2020. March 20, go to page number 30.
So what you are showing?
Page number 32.
Boundary description of the eco-sensitive zone around the Manarangata.
National Park in the state of Karnataka. Not towards east. Then it turns to southward, maintaining the parallel distance of 1 kilometer from the extreme point along the Karnataka National Park boundary to Vaderahalli, Gullahalli, the third line, Timmanayakanhalli village. Timmanayakanhalli village till it reaches the point on the interstate boundary of Karnataka and Tamil Nadu. This Timmanayakanhalli is the place where the firing license is got.
Put on affidavit with few lines of governments. 1st of July.
My lord, in the interim, if I may just pray for my interim order, my lord, I've prayed because I have been granted quarrying license previously, my lord. I may make my submission, sir. My lord, on the previous occasion, based on the inspection done by the inspecting officer as also the range officer, wherein my land has been identified being 1.1 and 1.2 kilometers beyond the boundaries of the reserve forest.
After this notification, your prayer becomes redundant. After this notification, your prayer goes.
Your Honor, but then the boundaries have to be identified, Your Honor. Being in terms with the 1915, because they've not conducted the survey properly. That is my whole contention.
Let them file, then we'll do, you deal with it.
The order of the competent authorities of the year 2015. That has not been challenged before the divisional authority. For the first time in the year 2020.
We understand.
24. It is delay also.
No, it is not delay in that sense. He wants to hold back, he says that map boundaries of 2015-16 may be revived. That is what they are saying.
They are contending 1915 boundaries.
15
have been
boundaries.
challenged.
They're not
They should
challenging
have
the
challenged in
boundaries.
Year 2016 itself. That is the case.
My lord, I will just reiterate, my lord, because time and again it's being said that I'm challenging the 1915 and the village map. I reiterate and I put it on record, I'm not challenging it. It will be too adventurous of me to do that.
We'll consider. Next.
Case number 38, so Vikram Muni Rajgopal.
My lord, the bank is before your lordships, my lord. The dispute arises in regard to a proposal for OTS. The borrower, my lord, is a contesting respondent. My lord, according to the bank, 26.35 crores, my lord, what was due in January of 23.
Your bank?
I'm the bank, my lord. The learned single judge, my lord, has held that they are entitled to the OTS since they paid, there's a dispute on that. Substantial part of it is what we say, they say fully. Therefore, the learned judge, my lord, has directed us to accept the OTS, practically directing us to modify the OTS. That's the direction given by the learned single judge. According, my simple case, my lord, is that the OTS has certain terms. If they did not comply with the terms entirely, I'm entitled to cancel the OTS. I cancelled it on the ground that they have not complied with it fully. There are two letters, my lord, in this regard. One of them gives the reasons. The second one, my lord, is a follow-up letter. The learned judge, my lord, has not perused the first letter, which gives the reasons and concludes that no reasons have been given by us. But reasons are there in the letter, my lord, I'll point out. There's already, my lord, an order, my lord, directing status quo to be maintained. My lord, could your lordships, my lord, notice page 72 is the OTS acceptance letter. Annexure E.
Earlier this was argued.
Yes, my lord, your lordships had occasion to hear it for some time.
Last occasion, your lordship said matter can be finally heard. Your lordship said matter can be finally heard and disposed of.
Yes, let us see. Now we'll complete this. Finish it.
My lord, at page 72, with reference to the subject, the proposal for OTS is permitted as under. Accept 1,800 lakhs towards full and final settlement of dues, 500 lakhs immediately on conveying sanction, 125 lakhs already paid and kept in no lien account to be adjusted immediately, balance 1,300 lakhs payable on or before 27/2/2020. OTS shall carry interest at MLCR 1 year prevailing on 1/4/19, that is 8.65 plus 1.05, that is 10.15 simple, on reducing balance till payment of the entire OTS amount after 3 months from the sanction date, and single default clause, etc. Then para E, the concession extended as above stands automatically withdrawn in case the company fails to remit the compromise amount within the stipulated time, and the bank reserves the right to proceed legally for recovery of entire dues in case the company does not comply with the above. The next page, not G. Bank reserves the right for withdrawal of OTS sanction at any point of time, even during the period permitted for payment of OTS, without assigning any reasons for withdrawal of OTS. Now, my lord, after this, what happened was they made one payment of 3 crores. Then, my lord, they asked for extension of time as per annexure F at page 75, which we. because COVID intervened.
Which judgment was cited, Supreme Court judgment?
My lord, there's a compilation, my lord, that I've submitted, two judgments, my lord, was whether the High Court should interfere, my lord, in matters relating to OTS.
Yes.
The first is, my lord, Bijnoor Urban, which is there in the compilation, 2023, Volume 2, SCC, 805. This is the latest, my lord. This follows an earlier decision in 2023, 1 SCC 540. I have filed, my lord, copies. Lordship Justice M.R. Shah's judgment, my lord. In the first one, my lord, your lordship recall, it was the Honorable Justice Nagaratna sitting with him. And in the second judgment also, my lord, in writ jurisdiction, can this be gone into is the question.
Auction was held,
Auction was held,
then
but auction, my lord, was stayed.
auction was stayed.
Stayed. So now what has happened is the money that he has given us is with us. It's only partial because as of January 23, the sum due was 26.35 crores. We agreed to accept 18 crores. Then, my lord, extension was given. The OTS letter said till date of repayment, interest is payable. That interest was not paid. So the bank cancelled the OTS. The learned judge directed that we should accept the OTS in settlement, full settlement. Now, by virtue of the status quo order, my lord, I cannot do any further auction. And in the last 1 year, my lord, this amount would have grown by another 2-3 crores of rupees. So about 30 crores of rupees is what is due. And what I have received now is 19 crores.
So today you are inclined to accept some OTS?
No, my lord. Now we are not in a position to accept OTS.
I have paid the full amount according to OTS. Question of acceptance. The question is, they withdrew after receiving the entire money. That is the point. OTS was for 18 crores. I paid 19.82 crores.
I'll point out, my lord, that what was the term, that's why I read the interest clause. If you see the dates, my lord, on which this.
You paid 19 crores?
I have paid 19.82 crores.
Already paid.
Already paid. And the OTS for 18 crores. One of my properties, Pillar, was also sold for an under price because it was a lower price because of the COVID. It was sold for 15 crores. They realized the money. Thereafter, I have paid another 4 crores, 3 to 4 crores.
No.
19.82 crores have been paid. Even then, they cancelled the sale, and now they are calculating compound interest.
No,
on
not
that
now. That is the term.
Why did you not accept the OTS?
My lord, that's what I want to point out, my lord.
Yes.
The extension OTS, my lord, which was given on 11/12/2020, as per Annexure F, on that date, my lord, 17.21 crores was due. 11th December 2020.
17.1.
Page number 75.
Page 75.
17.21 crores was due. And your lordships may now see, my lord, what are the terms of that at page 7. This is the extension of OTS. Page 75. The competent authority has permitted following. Extension of time permitted for payment of OTS amount from 22/2/2020, that is expiry of OTS dated 31/12/20, date of last installment, 313 days in making payment of entire OTS amount of 18 lakhs. 500 lakhs to be kept. OTS shall carry delayed payment interest and expenses of 214.92 lakhs, calculated at so and so rate, compounded monthly. 1500 lakhs plus delayed payment interest as stated above shall be paid on or before 31/12/2020. Security shall be released after receipt of the entire amount. This is the first extension. Then, my lord, kindly go to the second extension which they seek at page 147. That means first time given they don't comply. They say it is because of whatever COVID. We give them one extension.
247.
Yes, 147, 147. So the December 2020 deadline is not met. So they come back to us in January 21. As per company's request letter dated 16/12, time period to pay the OTS has been extended for the further period of 2 months. Hence, the last date for full payment of OTS is permitted up to 28/2/21, as against the earlier deadline of 31/12/20. However, extension in OTS period is subject to differential interest for extended period, which is calculated as 6.68 lakhs for 15 days from January 21. Details of interest calculation are annexed. Then right to reserve is there. Next page, your lordships may go to. In para 2, my lord, in page 147, they are acknowledging the receipt of 15.90 crores. There's a note, my lord, in the middle of that page. Note, there was one security given. They wanted to sell that security. So they decided to sell it. Further, the competent authority has permitted the following: release of one immovable property at so and so upon receipt of 1590 lakhs. This property has been released after receipt of 1590 lakhs to the company's account based on the board resolution of 4/12/2020. So what they did was, instead of paying me the money, they said there's one property which belongs to me, which I would sell. Please permit us. I will sell that and pay that money to you. So that was done. Then release of the remaining securities only upon receipt of the balance amount of interest amounting to 131.60 lakhs. So as of January 21, this amount was due. And clause 4, my lord, we specifically point out that if you don't comply with this, we are entitled to cancel. Clause 4 note. In the event of non-compliance with any of the terms of the sanction by the party, including payment of OTS amount as per stipulated schedule, the OTS sanction stands automatically withdrawn without assigning any reasons for the same. Bank reserves the right to proceed as it deems fit, including proceeding legally for recovery the entire dues. Next page, my lord, the calculations are there. So, my lord, he had paid 3 crores. Then this 15.90 was paid, making it 18.9. That is all that was paid before 28/2/21. Now, 28/2/21 is the second extended deadline for OTS that your lordships will get at page 147, the first para itself.
147 we read.
Yes, 28 at page 147, amount permitted to be paid before 28/2/21. That means 1 month was given from the date of the letter.
Yes.
We quantified it. We said you can pay 1590 by sale of property. Remaining, this is the sum due. You pay this entire amount by 28/2/21. Now, my lord, admitted position before 28/2/21, total amount we have received is 18.9 crores. This balance amount was not paid.
So balance was 131.60 crores.
Not paid.
Lakhs. Sorry.
So then, my lord, what happened was, they made a request to us to reconsider the interest. That means they admit it was payable, but they ask the bank to say, no, please reduce interest. That request your lordships will get at page 77. So they accept OTS, make a small payment of 3 crores, then come to us before the sale of this property and say, reduce the interest. Page 77. Number of reasons are given. And the request is at 79, last sentence of the letter. We are thanking you for OTS sanction. In short time, please reconsider the interest calculation as explained above.
This is after page 167.
No, this is after paying only 3 crores because this remaining 15.9 was paid in January 21.
47 is dated.
They paid initial 3 crores.
So
Then-
this is prior to page 147.
Yes.
So
Prior to. Lord, what happened was, first OTS given, they paid 3 crores, then they ask us, please reduce interest. Then they ask us, please extend OTS. We extend the OTS, but we reiterate interest is payable. That is what your lordship saw, my lord, in the extension letter at page 147. My lord, OTS means, my lord, we are sacrificing substantial sum of interest and other principal amount so that I get the money in hand immediately with a time frame. That's the whole purpose of OTS. If they take an OTS, my lord, I sacrifice from 26 crores, I come down to 18 crores and they don't pay in time. Then they come back to me for again concession of interest. I said, no, I can't give you any more concession. And I tell them this amount has to be paid before 28/2. They don't pay it. Then, my lord, the bank takes a decision at page 187. This is the letter which the learned judge, my lord, has not noticed. Page 187. Though it is part of the record, he has only seen the subsequent letter. So 28/2 was a deadline. Only 18.9 was paid. Interest of not 131 lakhs not paid. Then the bank takes this decision. Page 187. Withdrawal of OTS. As per company's request of 1612, time period to pay OTS amount has been extended for further period of 2 months. Was permitted to pay full OTS amount before 28/2/21 as against the earlier deadline of 31/12/20. However, the entire OTS amount has not been paid within the stipulated time period and as per the terms and conditions of the above cited sanction. Hence, the OTS sanction stands failed. Further recovery action, including action under surface, will continue. This is followed by another letter at the next page. This letter is 12th March. About 20 days later, the next letter is written. Please refer to a letter of 12th March 21, cited above on withdrawal of OTS proposal, continuation of surface action for recovery of residential liabilities. Present liability for your account is as under. Then we give the details. Now, one more fact which has come into notice, my lord, is that this person owned other assets. Normally OTS is given when the bank assesses and finds that a borrower is really incapable of making the full payment. So the bank takes note of his financial position and then says, all right, I'll receive something less, whatever, I can get. But in this case, subsequently, we come to know that he has other assets. So we go to DRT and we get some attachment orders against those properties. That, my lord, is a separate action, but I'm just placing that as a facet of the case. Now, after this letter is sent, they make two more payments. They are on 26th March 21, which is, my lord, 3 days after the second letter and about 3 weeks after the first letter. 52 lakhs. And on 10th May 21, another 25 lakhs. The total comes to 19.67 lakhs. While arithmetically, my learned friend is right that he has paid more than 18 crores. But what is not factored is the time frame within which that had to be paid and the terms of the OTS. Now, if some money is due in August of 2019, and paid in May of 21, naturally, my lord, interest on that has to mount because we are a bank and we lend monies, we take deposits and we pay interest on it. So it is customers' money which we are lending. Unless some very benign customer says, I'm keeping money with you, I don't want interest.
Yes.
So, my lord, in this, what the learned judge, my lord, notices in the order, if your lordship would now see, at page number 40, my lord, from 39, if I may read, learned judge refers to this letter, that is the second letter only, not the first letter. Probably it is, my lord, an oversight. Page 39, bottom. Last param. Based upon the said extension of deadline, petitioner pays an amount of rupees 18.90 crores. The said payment is not in dispute and the receipt of the said payment by the bank is also not in dispute. Page 39, bottom. On 23/3/21, what the bank would do is cancel the OTS or withdraw the OTS. The order withdrawing OTS reads as follows. Now, learned judge extracts the letter, which your lordship saw, my lord, at page number 188. This is the second letter. And this refers to the earlier letter also at page 40, if your lordship sees now. This is the extract of that same letter which your lordship has just now read. In the italics portion, there is a reference to the letter dated 12/3/21, which is annexure H at page 187. That is the one which gives the reason. After extracting this letter, the next page, 41, or page 41 in the judgment, the learned judge, my lord, continues the consideration and observes this, my lord. Page number 41, Lord. Page 41. The entire issue now revolves around the order of withdrawal of the OTS. A perusal at the order of withdrawal of OTS becomes clear that it bears no reason as to why OTS is withdrawn. The only reason indicated is continuance of a surface action for recovery of residual liabilities And the present liability as on the said date was rupees 63, 6 crore, 6 lakh 30,000, 63,082 lakhs. According to the order withdrawing OTS, no other reason is indicated as to why OTS is cancelled. And that's why, my lord, I respectfully submit there has been an error, my lord, on the part of the learned judge.
Yes.
In not noticing the facts of this case, which are not in dispute. We don't dispute that we have received 18.9 crores. That is not the entire sum due under the OTS. And in para 12, my lord, at page 41, the learned judge, my lord, in respectfully submitting, commits another error. And that is in observing that the full amount was paid. Para 12, my lord. Learned senior counsel appearing for respondent to submit that the amount was not paid in full, interest had to be paid. Therefore, exercising liberty that it had reserved to itself while offering OTS, OTS comes to be cancelled. No fault can be found with the said action. The submission in the peculiar facts of the case is unacceptable. So we made the submission before the learned judge that this is not paid. While the learned judge says, yes, that submission is to be corrected, but in the facts of this case, unacceptable. Then my lord goes on to say bank is Article 12, etc., etc. In the next page, my lord, one more error, my lord, with due respect I'm submitting. In the middle of page 42, the learned judge tries to, my lord, takes exception to the fact that we received that amount. Not if we give an OTS, if a party makes a part payment, said I'll make a further payment, I'll make a further payment, and before deadline I'll make the payment. Should we say, no, 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 you get all your money and come? That's what, my lord, the learned judge seems to think. Third line of page 42. It is not in dispute that the petitioner has deposited 18.9 crores by selling his property and the bank retains 18.9 crores and proceeds to auction other properties of the petitioner on the ground that the loan is not cleared. It would have been a circumstance altogether different if the petitioner had defaulted in OTS before the deadline that was stipulated with the bank on agreed terms and conditions, which was on 28/2/21. Petitioner had deposited 18.90 crores and later on 26/3/21 deposits 52 lakhs and on 10/5/21 deposits 25 lakhs. All these amounts are accepted by the bank. In one breath, amount is accepted. The other SURFACE proceedings are instituted by cancelling. If the bank had cancelled the OTS, it could not have retained the amount paid under the OTS and put the property of the petitioner to sale as well. The OTS letter clearly says that if you don't comply, I have a right to cancel it. And factually, it is very clear that he didn't comply. Therefore, the bank legally exercised its right. Can this be considered, my lord, as an arbitrary action in warranting interference in Article 226? It's a commercial decision exactly in conformity with the provisions of the OTS and the rights of a lender. Lender is not abrogating all his rights. He is reserving his right for the liberty to initiate action. Therefore, my lord, I submit. And my lord, I cited this case also, my lord, at page 43 and 44. And it is, my lord, distinguished, my lord, if I can say so with respect, perfunctorily. Saying, my lord, that the judgment is distinguishable without much ado. My lord, that decision lays down that OTS should be viewed strictly. And then, my lord, the conclusion that the bank acted, my lord, not in such a fair manner at paragraph 15 is also, my lord, due respect, uncharitable.
Yes, and we'll continue tomorrow.
Please.
My lords,
When shall we continue? Tomorrow or?
I mean, your lordship stands, my lord, any day, my lord, tomorrow or any other day. I'm okay.
Tomorrow
Okay.
we'll devote some time at 1 hour.
Please, please.
I think by 1 hour it'll be over.
Yes, yes, I'll take only another 5 minutes or 10 minutes.
Tomorrow it can, should be in the second half.
Please.
Any other date you want, please tell us.
Or any day on the 12th, my lord, can it be? On 12th or 13th, is it possible?
12th.
12th or 13th?
12th.
13th, my lord.
12th.
13th.
13th. All. 13th, any matter is there?
Yes, please, please. Interim order may kindly be continued, my lord.
Lord, I have a memo of calculation. Should I?
Interim order may kindly be continued.
10 or to
Oh,
13th,
calculation.
interim order granted earlier shall continue to operate.
I have a memo of calculation. Can I
Maybe
file
next.
it on the next day, my lord? I have prepared a memo of calculation. Should I file it now or on the next date of it?
Memo of calculation.
Of the amounts paid, which was there before the single judge.
By the next date, both of you can prepare a shorts,
Very well.
dates and events.
Please, my lord, we'll do that.
my lords, humble submission on serial number 60, my lords.
Then file a,
My lords,
or
my lords,
by publishing advertisement. File a IA for this. It will be extra.
That's one submission, my lord.
my lords, 60,
In all matters, interim orders will be extended.
That's
My
one
lord, if I
submission,
can-
my
my
lord.
lords,
This some
Lords,
urgency, my lord,
58,
next week, lord.
14%.
But the pollution control board has not given the consent for operation. 700 workers or my lords have to pay salary. Next week, any date, your lordships have heard this before vacation. 53, your lord.
14%. Serial number 58. The short date may for reinstatement into service.
What is contempt?
And the court has filed writ appeal.
For July.
Short date.
Interim order. Serial number, my lord, serial number 62,
serial
my
number
lords.
60, my lords.
For July.
That's
beyond-
serial number
before that-
6, my lord, one submission, 62, my lords, to hear before charge. It's a 2017 old contempt. The order of the single judge has been upheld in the
Take
writ
dates
appeal.
now.
Request for a short date,
Serial
my
number
lords.
60, my
next
lords,
week.
it's a matter for disposal, my lords. Serial number 60, my lords, it's a writ petition, writ appeal, my lords. It has already been disposed by this honorable bench only, my lords. A similar subject matter is posted for today, my lords. Kindly, if you could dismiss the same on the same grounds, my lords.
Let's see. That's 62, my lords.
60,
Order
my
this-
lords, serial number 60. Writ appeal number 1067 of 2023, my lords. Similar connected writ appeals have also been filed, my lords. Writ appeal number 1068 of 2023 and 1138, my lords.
No, let it be tomorrow.
My lord, one
My lords,
mention, my
all
lord.
these connected matters can also be posted for tomorrow itself, my lords.
Without saying the matter, we will not even dismiss the matter. Yes.
My lord, one
Let's,
submission.
62, my lords are having it next week, my
25
lords.
Tuesday.
Lords, I
My lords.
My
53,
lord, with regard to,
some urgency in the matter. The pollution control board has not given the operation consent. Next week, your lordship.
My
That's
lord-
62, my lords.
my lord, 64, it's a matter with regard to some loans which were given. And there is an order which has not been complied with. We are for the bank, my lord, serial number 64.
So what do you want?
And there was a order to deposit 5.25 crores. That also, there's no compliance with regard to that also. If a short date may be given in this matter, it's for final hearing.
Well,
Lord, 62, my lords are having it next week, my lords. Lords, the order has been confirmed up to the Supreme Court, my lords, still, but still they're not complying with. Next week, any date, my lords?
the 3 weeks.
Serial number 59. The office of objection has already been overruled.
Very
And this honorable court has already overruled the office objection.
Very good.
And now it may kindly be, again, they have said that office objection, it may kindly be overruled.
Over. Thing is over, including your request, yes.
Well, July.
Posted on 18/7.